Anna, just FYI, I do show that we're on YouTube.
Good morning, Judge.
Good morning, Mr. Lee. How are you, sir?
Good. The PRC from Friday should be in your inbox shortly if it's not there already.
Yes, I just saw it. Thank you very much for getting on it so quick. We appreciate it.
No problem at all.
We're probably guessing this hearing probably go to about noon, possibly into the early afternoon today.
Okie doke.
So that's the expectation.
Sounds good. I'll see you in 15 minutes.
Okay, sounds good.
This audio working? Can you hear me,
Yep.
John?
I can. Can you hear me?
Yep.
Good. I have a few people in the waiting list.
Can you make me a co-host? Just
Yeah, doing that right now.
Morning, Judge.
Julie, how are you?
I'm hanging in, my friend.
Yeah, me too. This weather's crazy.
It is, but I'm ready to saddle up and ride for the brand.
It's just all that wind. And then apparently there's like all kinds of tornado warnings for the Midwest. I guess that system that we got yesterday, it's going to move through and cause all kinds of problems.
Now we got next to nothing, and they get just about everything.
That's right.
Yeah.
Well, that wind was pretty intense. I mean, I don't know about you guys, but man, it was like,
Yeah.
it was pretty. I was like, huh, is my house? I don't think my house was going to fall over, but you could feel like the windows were like, oh, had
Yeah,
to
I think-
resist.
I think there was an
My-
article in the New Mexican that knocked out Wi-Fi for a large part of Santa Fe.
Right.
My hat fits snugly on my head, and it was begging to get away yesterday.
All right.
uh,
I'm going to go ahead and let him in. Hearing examiner Ryan, unless you have any concerns with that.
no, it's fine.
Okay. I do show the chair is waiting to come in too.
Yeah, Commissioner Nybert is away, and I believe so is Commissioner Aguilera. I understand they're at some sort of conference, so I don't think
Okay.
they'll be joining us.
Morning, Mr. Chair.
Yeah, good morning.
Is that right, Commissioner, that Commissioners Aguilera and Nybert are at some sort of conference today?
Yeah, they're at the CREPC meeting in San Diego, so be surprised if they call in.
Good morning. Can anyone hear me?
Yes, I can hear you. Is that Mr. Monroy?
I can't hear anyone.
We can hear
We
you,
can
Mr. Monroy.
Yeah, we can hear you.
I can't hear you. Let me see.
That'll make for a short hearing.
Morning, Mr. Atencio.
Good morning.
Sometimes I find it just undoing your unplug it and then replug it back into the USB.
Let's see. No. Did that work?
We got
Yes.
your audio.
We can hear you.
All right. I can hear you now. Sorry about that. Good morning.
No, sometimes
No
that's always what
problem.
that's why there's value of getting the USB headphones, because your machine, it has to get the audio card and then like the mic to be like syncing up. And sometimes the only way to do that is like forcing that reconnection with the jack.
Awesome. Thank you.
Okay. I show that it's 9 a.m. Does anybody know, are we still waiting on anybody, or we okay to go ahead and get started?
I'm ready when you're ready to go on the record, Judge.
Okay, excellent. Well, good morning. The time is now 9 a.m. We'll go ahead and go on the record. This matter before the New Mexico Public Regulation Commission will please come to order. This is the time and place set for the evidentiary hearing in the matter of Public Service Company of New Mexico's application for approval of purchase power agreements, energy storage agreements, and certificate of public convenience and necessity for system resources in 2028. This case has been docketed as case number 24-00271-UT. My name is John Kreinkamp. I'm joined today by Christopher Ryan. We are the hearing examiners with the PRC who will be presiding over this matter today. This case and this hearing this morning involves an uncontested stipulation. Following the hearing, the responsibility of the hearing examiners will be to produce a certification of the stipulation with a recommended disposition. The hearing today is being transcribed by a court reporter. For the sake of that record, we'll go ahead and start with entries of appearance from all parties present, starting with PNM.
Morning, Mr. Hearing Examiners. Christopher Atencio for PNM.
Good morning. Let's see, Utility Division staff, Mr. Rossi.
Good morning, Nicholas Rossi for PRC staff. Thank you.
Good morning. Next on my list, Bernalillo County.
Good morning, Mr. Hearing Examiner. Mara Demille for Bernalillo County. I'll be joined later this morning by Valerie Joe.
Excellent. Good morning.
Thank you.
Let's see, Central Consolidated School District.
Good morning, Jermaine Chappelle appearing for Central Consolidated School District. And I did also want to let you know, Hearing Examiner, that the board has agreed to file as a signatory in the case, which probably will be filed later today.
Okay, thanks for letting us know. I appreciate it. Next on my list, ABCWUA. I believe that's Mr. Herman.
Mr. Examiner, Keith Herman with ABCWA, Albuquerque Bernalillo County Water Utility Authority. And just as a preliminary matter, I'm willing to waive all my cross-examination and objection to any exhibits. So with that, I would drop off and go to the YouTube feed if that's all right.
Okay, yes, that's no problem. I was going to address excusals just in a minute, but yes, for the record, you
Thank you.
certainly can be excused. Thank you. Okay, Bernalillo Solar. No. TCAE. Mr. DeSalem.
Good morning, Mr. Hearing Examiner, colleagues. Charles DeSalen representing Coalition for Clean Affordable Energy. I believe Kara Lynch is also on the platform, also representing CCAE. And we do not have a witness in this matter, and we will waive all of our cross-examination, at least preliminarily. But I expect that either myself or Ms. Lynch will be on for the duration of the hearing. Thank you. We do support the stipulation, of course.
Okay, thank you. And while we're on the subject, Prosperity Works, Ms. Lynch, are you representing them in this proceeding as well?
Morning, Hearing Examiner. Yes, I'm here representing Prosperity Works, who was also a signatory to the stipulation, and we will be here for the duration of the hearing as well.
Okay, thank you. Let's see, New Mexico Affordable Reliable Energy Alliance, Ms. Gould.
Hi, good morning, colleagues. Good morning, hearing examiners. Kelly Gould for New Mexico Affordable Reliable Energy Alliance, or NMAREA. Thank you.
Good morning. And last on my list, I have Western Resource Advocates, Ms. Beatles.
Good morning, Chairman O'Connell, Mr. Hearing Examiners, colleagues, Sydney Beatles for Western Resource Advocates.
Excellent. Good morning. Did I miss anyone today, or has everyone entered their appearance? Okay. And then next up, we are joined this morning by the chair of the commission, Chair O'Connell. Do you want to just introduce yourself, I guess, for the record?
Yeah, good morning. Pat O'Connell, Chair of the New Mexico Public Regulation Commission. Thank you all for being here today. Looking forward to a good hearing. Thank you.
Excellent. Thank you. Okay, so just a few procedural items to address before we get started. So first and foremost, counsel for two parties contacted the hearing examiners yesterday requesting to be excused from today's hearing. My understanding is that they CC'd the rest of the service list, at least by all indications. Those parties were New Energy Economy and the New Mexico Department of Justice. Those requests to be excused were granted. So those attorneys are excused from today's hearing, as is Mr. Herman. Are there any other parties who would like to ask for an excusal while we're on this subject?
Mr. Hearing Examiner, this is Kelly Gould. I will be in attendance, but I would request to be able to turn off my camera periodically.
Okay, that request is granted.
And Mr. Hearing Examiner, Bernalillo County has taken no position on this matter. We didn't intend to engage in any cross-exam, introduce exhibits, etc. So we would respectfully ask to be excused, would like to watch this from the public portal, but feel that would be probably more appropriate than actively participating today.
Okay, that's no problem. That request is granted. Absolutely, you're excused.
Thank you, sir.
Thank you, appreciate it.
And hearing examiner, my apologies. I wanted to make the same request as Miss Gould.
Okay, no problem. Yes, you can
Thank you.
absolutely turn your video off.
Who was that speaking?
I believe that was Ms. Chappelle.
My apologies, court reporter. This is Miss Chappelle, with CCSD.
Hearing examiners, Prosperity Works and CCAE also request periodic times when we'd take ourselves off camera.
That's fine. Yes.
Okay.
Okay. Now, among the interveners, I believe the only party who did not take a position on the stipulation and has not yet been excused at this point would be Bernalillo Solar. I just want to confirm that we do not have Bernalillo Solar on the line. Okay. Oh, Mr. Early. Okay. So I do not see Mr. Early in my list of attendees for some reason, but I do see that he's sending a message saying that he's having audio issues. He's also asking to be allowed to go off camera. Those requests are granted. Unless you do have any questions on cross-examination. Okay, so that's been addressed, hopefully. Okay, so as far as the structure of the hearing today is concerned, given that this is an uncontested stipulation, and therefore cross-examination, at least from the signatories, would be friendly cross-examination. We don't need to worry about time limits today. We are aware the parties have conferred with one another and submitted a proposed order of witness examination. That's fine to us. We'll go ahead and work off of that. Hearing examiner Ryan and I did confer briefly prior to the hearing this morning. We do anticipate that we will have questions for all of the witnesses. So right now, I don't think we're in a position to excuse anyone from testifying. But if that changes, obviously we will address that. Just to reiterate what that order of examination will be, we start with Pnm'S witnesses, Mr. Monroy, Mr. Duane, Mr. Barnard, Mr. Jenkins, Mr. Wintermantle, and then we'll finish with Mr. Nagel, and then we'll have staff's first and only witness, Mr. Zigich. And I think with that, are there any preliminary matters or questions from the parties that we need to address before we begin the hearing this morning? Okay, seeing none. With that, Pnm, you can go ahead and call your first witness.
Thank you, Mr. Hearing Examiner. Pnm's first witness would be Mr. Henry Monroy.
Mr. Lee,
Good
if
morning.
you please swear in Mr. Monroy.
Mr. Monroy, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir.
Thank you. And good morning, Mr. Monroy. Will you please state your name and job title for the record?
Good morning. My name is Henry Monroy. I currently serve as Vice President for Regulatory for Public Service Company of New Mexico.
You have before you what's been labeled Pnm Exhibits 1, 2, 3, and 4.
Yes, I do.
Can you describe what these documents are?
Sure. Exhibit number 1 is the unopposed comprehensive stipulation filed in this proceeding. Exhibit number 2 is the direct testimony in support of stipulation filed by myself. Exhibit 3 is the application in this proceeding, and Exhibit 4 is my original direct testimony filed in this proceeding.
Thank you. Did you prepare or supervise preparation of these exhibits?
Yes, I did.
Are they true and accurate accounts to the best of your knowledge?
Yes, sir.
Do you have any additions or corrections to them?
I do not.
For exhibits 2 and 4, your testimony in support of the stipulation and original direct testimony, if I asked you the same questions today, would your answers be the same?
Yes, sir.
Thank you. Mr. Hearing Examiner, I'd move admission of PNM exhibits 1, 2, 3, and 4 to the record.
Okay, thank you. Any objection to the admission of Pnm's exhibits 1 through 4? Seeing none, Pnm's exhibits 1, 2, 3, and 4 are admitted into the record.
And that's all the questions I have for Mr. Monroy and would make him available for any other questions.
Thank you. Okay, so cross-examination, having effectively been waived by the parties, the only, let's see, Mr. Early, I don't believe I heard from you earlier about cross-examination. Do you have any questions for Mr. Monroy?
No, we do not plan to have any questions for any of the witnesses, Mr. Hearing Officer.
Excellent, thank you. Okay, so with that, Hearing Examiner Ryan.
And I'll defer to Commissioner O'Connell if he would like to proceed.
Yeah, thank you. I just have like one kind of big picture concept I wanted to get straight in my head. So good morning, Mr. Monroy. Could you just summarize what the need for these resources is?
Sure. Good morning, Mr. Chairman. So really looking at the need in 2028, which is when these resources are targeted to be available. We're still targeting a summer, kind of the summer, make sure our summer peaks are served. If you really look at where we are before us adding any resources, we have a reserve margin that's effectively zero, approximately 0.1% reserve margin without the addition of these resources. And we have a LOLE, or a loss of load expectation, of 2.01 days. So really, that drove the need for the resources that we proposed in this application to make sure that these resources come online. I think they're all scheduled to come online at the end of 2027 or January of 2028, to make sure those resources are available to strengthen those reserve margins and make sure we can adequately provide service during our peak seasons.
Yeah, great. So I was reading that correctly. It's summer 2028 is when it really starts to bite. And then I guess just to feel, like you've got summer of 2028 covered, when do these resources have to be online?
Sure. So, I think with the proposed timelines we have and the expectations, the expected commercial operation dates, like I said, are either December of 2027 or January of 2028. I think that gives 5-month cushion in case there's any delays. I'm not aware of any, but it's a world that's a little out of some people's control this time, at times. And so I think really, we've kind of learned from our previous mistakes and really are trying to get these applications in a more timely manner before the commission to ensure there's adequate time for the developers to build the projects, come online. Really, I think the goal would be for sure we want them up, easily April, May, just to make sure they're all testing and running fine, so ahead of the summer season. But like I said, under the contracts, we're expecting to come on at the end of 27, so that should allow plenty of time ahead of the summer peak season.
Great. Yeah, and then that matches what I'm seeing in the stipulation, and then just want to confirm, Valencia, that's an existing plant. Is there any interruption in availability of service to Pnm's customers with that?
Yeah, sure, Mr. Chairman. No, the existing PPA runs currently through May of 2028. This contract would then begin in June, so there wouldn't be any interruption as designed.
And then Sun Lasso got a expected commercial operation date of January 15th, 2028, for his own expected COD of December 31st, 2027. And those are both contracted resources, correct?
That is correct.
So how is PNM gonna oversee, monitor, manage the construction of those resources to make sure that they're online by the expected dates?
Sure, Mr. Chairman, thank you. My understanding is there's, like I said, there's an estimated completion date that has some requirements within those developer contracts that kind of ensure they meet the development milestones. There's also penalties that are obviously available to PNM if the developers don't meet the expected deadlines to kind of ensure the developer has the proper incentives to make the commitments that are included within those contracts.
And then who at P&M is going to be monitoring or managing those contracts?
That would be Gary Barnard.
Okay. And then the one with the latest in-service date is Sunbelt. Says expected COD of May 1st, 2028. Is that cutting it a little short compared to summer peak of 2028?
I believe so, but I think especially with the timeline that we're on today, I think, getting an approval will help alleviate some of that. I think that was contemplated on a September 1st approval. And so any approvals that can happen quicker, we'll initiate those contracts and get those going. I will, Mr. Chairman, I do think probably Mr. Barnard can give you a little more assurance on the development. But that's my understanding that it's kind of a month for month. The faster we can get started on that, those dates move up.
Yeah, I mean, Mr. Monroy, you might appreciate our shared history at P&M. I'm looking for the one neck to grab, and I'm hearing all roads lead to Mr. Barnard on this.
Yeah, Mr. Chairman, I think that's fair. That's kind of his role in the organization. But I'm not trying to put him on a leaf. As the policy witness in this case, I think I'm accountable to making sure.
Yeah, no, understood.
Everything is done.
And then just last question and accountability. Who does Mr. Barnard work for?
Mr. Barnard currently reports to Mike Mertz, who's our Senior VP of P&M Operations.
And is he a P&M employee?
I think Mr. Mertz is probably a shared services employee. I'm not 100% positive on that, but
Okay.
he is 100% dedicated to P&M.
Okay. Yeah, thank you. That was just what I wanted to explore. I mean, we've had trouble in the past of getting resources online, and want to make sure P&M has direct hands on this to make sure that things come online in time for when they're needed. So I appreciate your time and your testimony this morning. And hearing examiners, that's my question.
Excuse me, Mr. Monroy, could you spell Mertz?
Oh, yes, it's MERTZ.
Thank you, sir.
You're welcome.
Let's see, hearing examiner Ryan, are you still with us?
Yeah, I am. My camera is toast to DisplayPort problem. So I've alerted our IT department to come up and fix that, and they'll do that as they can. I do have questions. I could flick it on and off now, but now the whole thing's done. So I'll just have to be off camera until our break at 10. So sticking with that line of inquiry, Mr. Monroy, one of the questions I was wondering about as I was reading the PPAs is, just examining the contracts and then the testimony. The penalty provisions that exist within those contracts, if the developer falls behind or for whatever reason can't complete it on time, we saw that play out with pandemic time with supply chains, and then interest rates went sort of a whipsaw moment. And the trend for all the applicants or all the investor-owned utilities in New Mexico was effectively to go back to the developers and then just renegotiate the deals based on, I guess, what had to be the price. And I guess I'm wondering if, having gone through that experience, the commission should be concerned now about that possibility again. And I think Commissioner O'Connell's questions are sort of pointing in that direction. And the thought I had in my mind is, we live in a tumultuous time at the federal government level, and the talk of tariffs and international trade. How real of a concern is that? And then, is there adequate provisions within those contracts to make sure ratepayers are going to get the benefit of these agreements as structured?
Yeah, sure. Thank you, Mr. Hearing Examiner. And, I'll probably default or defer to Mr. Barnard to probably get into a little bit more of the specifics. And he just has a lot more experience working with developers and probably has a better feel for things. From my perspective, I think a couple of things. I think that's why, Pnm's utility finds value in having a mix of both utility owned and contracted resources. I think the utility owned resources, the utility has a little bit more influence with our EPC contractor. The Sunbelt project is with Gridworks, who is a domestic provider. And I think I commented that in my testimony, but I think that kind of helps, understanding that developer, and they have some diversification of supply. The batteries under that project, my understanding, is manufactured here in America. So I think having that kind of a diversification of resources that are being proposed helps alleviate any one risk. I think there's always some natural risk that, we're in the game of just risk mitigation to make sure we can deliver these resources to our customers. So I think we focus on that diversification in the portfolio selections to kind of mitigate it. I do think there's an advantage of getting these resources in now as we see what happens in the federal landscape. Future uncertainty with IRA and potential tax credits, but they're in existence now, and so I think it's opportunistic and really in our customers' interest to capture some of that certainty now as we move forward with our resource portfolio. But specific to the contracts and kind of having a better feel, I would probably suggest Mr. Barnard would be a great witness to give you a little bit more comfort of developer relationships and how they manage that risk on making sure they come to fruition on time.
Yeah, and I guess I'll happily do that. And I suppose just from the broader perspective, I just am wondering if the company, learned lessons from the last go round with uncertain times, and then sort of made sure to structure these contracts so that the companies that are proposing to develop these resources understand they're actually obligated to do it and will incur penalties if they fail to do so.
Yeah, Mr. Hearing Examiner, I think that's correct. Like I said, I think Mr. Barnard can give you details on the contracts. I think one of the biggest risks is just timeline and delivery, which is really, I think that's where we've learned from our lesson and really trying to get these applications to allow plenty of time for the commission to review and not go up against the tightest timelines for the developer. Then once we receive that approval, and we kind of can move forward to kind of give them enough bandwidth that they can deliver under those timelines. So I think that's one thing we've tried to address is a little bit more timeliness of just getting these resources before the commission and making sure the developers can adhere to the timelines they're given, that they're committing to in those contracts, by giving them a little bit more time. That way they have some contingency on their own end.
Yeah. When you're discussing the reserve margin with Commissioner O'Connell, you made note that it was, I guess I was just wanting clarification. So the reserve margin would be a percentage, and what is the target reserve margin? Having so many percentage above demand, is that basically how that works?
Yeah, you want to have adequate resources that are above what your forecasted demand is to be able to handle any of the reserves. I know we target a 0.1 LOLE. I think as the system has evolved and as you look at, when your risk hours are versus just looking at one peak demand and then trying to make sure you have an adequate planning reserve above that 1 hour for the year. And so I know we target a 0.1 LOLE standard. And then the planning reserve margin tends to be an output of that LOLE. And this would be subject to check. I really appreciate, if Mr. Dwayne could confirm it, but my understanding, 0.1 LOLE currently equates to around a 16% planning reserve margin.
Okay. So when you were describing to Commissioner O'Connell the okay, the 0.1 refers specifically to the loss of load expectation, and then the planning reserve margin is a percentage. And I guess that my question was ultimately, if you weren't going to if these resources were not approved, or had you even just not even applied for them, what would have been like your percentage above demand, or would you not be above demand? Do you see what
No,
I'm saying? Like,
I do, Mr. Hearing Examiner, and I think where the confusion comes in, the planning reserve margin, absent
right.
any of these resources, is 0.1%.
Okay.
And so that's not the 0.1 LOLE planning standard. So I apologize for that confusion. Yeah, it's just the actual calculation in 2028 is 0.1% planning reserve margin, whereas I think we target 16%.
And is that planning reserve margin something that's subject to be increased moving forward? I'm trying to remember from 21-215 to now where the movement has been in that.
Yeah, I think, from my perspective, I think at one time we had a 13% planning reserve margin. But like I said, I think from the most recent resource cases that I've been a part of or that I'm aware of, really that planning reserve margin has really evolved into the LOLE standard. And we've been using the 0.1 loss of load expectation of 0.1 for, I think, for 2 or 3 resource cases at this point. And so it's really moving towards looking at the risk hours that we're having to address to make sure our customers still have reliable service, that we can meet their expectations and meet their demands. And like I said, the planning reserve ends up being an output or a calculation as a result of that loss of load kind of study and expectation. And so I think as the system has moved to more intermittent resources, I think that has increased the need to look at how we plan for our system and really evaluate other factors as we make sure we can demonstrate to the commission and to our customers that we have adequate resources to provide safe and reliable service.
The Valencia power plant, I recall I was a participant in and I'm pretty sure it was 21-215. I know eventually that the numbers on those cases got a little weird. I think it started out as 21-00083 and then became 21-00215. But that was a proceeding in which Mr. Throne and Mr. Falgren had extensive discussion about Valencia. And I recall Mr. Falgren sort of using the baseball metaphor to indicate that, if he was thinking about the lineup in terms of these resources, Valencia was last in the batting order every time. And I think that's like a direct quote. I remember him saying those words. If it wasn't that, it was something very close to that. And I recall in the IRP, I don't remember which year this was, but the projection was that, Valencia would be abandoned in the immediate near term. And I'm just trying to understand what changed and why now continue the resource for a considerable amount of time.
No, thank you, Mr. Hearing Examiner. And I'll give you my perspective, and then this is probably definitely, I think probably Pnm witness Dwayne could probably provide the technical and more accurate answer. But, I think where we're at, and as we move forward to the energy transition, you see 4-hour storage is really the technology and the resources that are available for us to kind of contract now. The desire and the need for longer term storage is really, we see it in the IRPs, we see it in the out years, is really where we're heading. I think the value as we've moved, as the system has transformed away from, dispatchable resources into our current portfolio, I think the value of natural gas being able to be called upon very quickly, whereas we may not need to run it all that much. It's a great resource that can be called upon, that can come online very quickly and really provide that stability for when we need it, especially when you're looking at a resource planning. And so I think that's where the value of that plant really comes from. One thing to take into consideration when we model these things, we have our new emission limits, the 400 pounds that we're currently under today. And so even with those emission limits, so that kind of tampers down on how much we'd be using that facility. I think the overall stability and value of having a quick start load side generation kind of in our load pocket is really why the selection for that resource kind of was selected in our portfolios.
in terms of the actual impact to customers, as far as what cost this will be, I see that I didn't find in the application, and I went back to 21-215 and looked as well to see when those resources were proposed as the Palo Verde replacement resources, if a rate impact had been, or so estimated bill impact was provided, and it doesn't appear that was done there or here. And I guess my question was, is that can PNM do that, or is there a reason you guys aren't able to provide bill impacts just for the resources altogether that we're looking at here?
Sure. I mean, I think PNM could. I think one of the reasons for the approach that we take is we're not necessarily asking for the rate treatment to be defined. And as as the commissioners and hearing examiners are very aware, how energy storage agreements are allocated to customers is an ongoing debate, and making sure that we have that right. We have provided the first year revenue requirements of each of those resources on page 3 of my testimony. Just to give a little bit of context there, the Valencia power plant, the first year revenue requirement's about $22.2 million. That reflects anywhere between 1 million and 2 million increase from what we've seen and what's been in customer rates associated with that plant. That's the demand side of the Valencia contract. So very minimal change customers will see to that. Will be a slight increase. The 2 ESAs plus the Sunbelt project total approximately $55 million of incremental revenue requirements. Just as a rule of thumb, if you use current allocations, you just, how we're doing it there, about $10 million increase related to specifically to ESAs, how they were allocated in the cost of service that was filed in the case 24-00089. So that's kind of the parameter being using. About a $10 million increase is about a 1.2% residential bill impact. So on a rough basis, if you think of 55 million, that's probably 5 to 6% on a bill impact that a residential customer may expect to see. To put that in context, the alternative without these resources, though, would be that the PNM would have to contract into the market and try to, acquire capacity, off the wholesale market, which would be obviously a much larger cost to our customers.
So I'll ask Commissioner O'Connell, since he's with us, and I think I guess the question is, would you, Commissioner O'Connell, benefit from receiving sort of a more, I thought that was helpful, for instance, what Mr. Monroy just described in terms of like percentages. I mean, that's back of the napkin kind of math, but would it be helpful to the commissioners to have a sort of more granular projection of how we think these resources will increase rates? I mean, we understand that a lot of those variables aren't resolved, and it's probably just a best guess at this point. Is that something you'd like, Commissioner O'Connell?
Well, yeah, frankly, that was going to be my questions for staff, is how they had dug into that.
Great. And so, Mr. Monroy, I mean, I think to the extent to which we can get a clear, I understand your point about, there's so many variables, but all things constant, and what we know from 24-00089, what is the likelihood of what's the impact on the average ratepayer of these things? Is that acceptable, Mr. Monroy?
Mr. Hearing Examiner, yeah, we can use kind of a static starting point of the cost of service and the rate allocations that's included in the proposed 24-00089 as the starting point, and then we can model using all those assumptions kind of what a bill impact may be.
That would be very helpful, I think, to myself, and I'm something commissioner too. Sticking on 24-00089. So I think I should know the answer to this question because I'm involved in that case. But I just want to, these resources we're talking about in this case, I'll just go out on a limb and say, I understand that they are not incorporated in the rates we see there. Is that correct?
That's correct. That's correct.
Okay.
And these are all expected to come online after the test period that's in 24-00089.
Okay, so this is the rate making of this will be to be determined in the future.
Yeah, I think what we've said in this testimony and what the stipulation says that we'll
Right.
follow the rate making for energy storage agreements
Right.
based on the outcome of the 24-00089 case. So whatever the and that proposal, just as a reminder, was that the ESAs would be recovered through base rates.
Right. We started in the other rate case. You wanted them in the fuel clause, and then we had that whole development. So I understand. So and if I understand correctly, then too, since 24-00089 decided, well, ESAs will go through base rates. These ESA rates in this case and some future rate case will also be going through base rates. Is that right?
Correct. We're proposing that these follow the same treatment as was proposed in the settlement and the stipulation in that case.
Perfect. Thank you. Why is the Sunbelt project the only self-build here?
I think that's one of the projects that PNM submitted into the RFP or the evaluation process. If other self-build projects were submitted, that's probably a question better asked of Tom Dwayne. I'm not aware if other projects were submitted through that process and just not selected as part of the least cost portfolio. But my understanding is this was the resource that was the least cost located in the CCSD, and it happened to be utility owned. I'm not aware if PNM submitted other utility owned or self bid projects within that evaluation process. So you probably would need to ask Mr. Dwayne if he's aware of other projects that were submitted that just weren't selected. But I'm not aware of any that were submitted.
And when I guess I don't know, my assumption was, and I'm totally aware it's just purely an assumption, was that's a unique circumstance in that the build is occurring as a consequence of agreements and other legal authorities, and somehow that made it kind of a unique construction project, and so therefore PNM kind of took it on itself to do it. Is that just pure invention on my part, or is any of that true?
Unfortunately, I'm not necessarily terribly involved in how we make those decisions on what gets submitted into the RFPs. I mean, a little of that's of design, just so I can talk from a policy perspective. We try to keep certain of those things insulated from others. So I think as far as generation development and how those decisions are made on what can be built out, what could be submitted into the resource plans, and what makes sense for our customers, I'd probably refer you to Mr. Barnard. He can probably give a little more context on how self-build proposals are developed and how we think of those and what our view is on there. I will say in my testimony, we do view a mix of utility owned or self-build ownership with contracted resources an optimal mix. I think for the reasons laid out in my testimony, I think there's some contrasting benefits to kind of hedge against any one risk that you see. And so I do think there is a mix that's appropriate, but as to the specifics of how those projects or the self-builds are developed and ultimately proposed, I would have to defer to Mr. Barnard.
Those were just questions I had for you based on the application as I was reading now turning to your direct testimony. Pages 3 to 4, you write there, PNM is supportive of placing cost-effective resources in the CCSD, Charlie, Sam, David, Central Consolidated School District. Although the resources in this proceeding are not being proposed as replacement resources as that term is defined in the ETA. Can you just explain? All right, I guess I'm a little confused myself as to what the ETA required and what the obligation was coming out of the San Juan abandonment case. And then, the 23-253 case, there was an uproar over whether the company was building sufficient replacement plant up in the Central Consolidated School District. And then I saw this statement here, and I was kind of I was a little confused, frankly. Like, what I thought that's why the whole purpose of putting this in the CCSD is these are replacement resources. So if you can just help me understand better That would be very helpful to me.
Yeah, sure, Mr. Hearing Examiner. So, and I'm not a lawyer, but from my perspective, to be a replacement resource under the ETA, there was additional requirements, meaning there was even specific requirements on the RFP that was issued to qualify as a replacement resource under the ETA and under that legislation. As this commission is well aware, and as you're well aware, the original portfolio of replacement projects included a 130 megawatt Rockmont project that was going to be located in the CCSD. That project defaulted and so never came to fruition. PNM still believes it's a worthwhile goal to achieve what was originally intended in that order of locating that magnitude of resources in the CCSD. However, from our perspective and my understanding of the decision in the 19-00195 case, or the San Juan replacement resources, those resources were proposed, accepted, one defaulted. The obligation or requirement under the ETA was therefore met on where those specific resources would be applied. Recognizing one of those projects defaulted, recognizing that the ETA contemplated up to 450 megawatts to be located in the CCSD. That's where you see PNM is supportive. We're supportive of the Sunbelt project because we think it achieves those policy objectives of, locating in the CCSD. And on top of that, we think it's a cost competitive resource. I mean, I think it's not like that resource has a, exorbitant premium or looks out of sync with other resources and other costs that we're seeing. So, I think it achieves both locating a project in the CCSD. I think what we're trying to be clear here, what I was trying to be clear here is we're not saying that that this resource must be approved under the law and legislation of the ETA, but it still meets that policy goal and the intention of the previous orders and kind of what the ETA described.
So I guess just hearing that answer, what I think would be very useful, and I'll just do this now because I don't want to forget this point, but Mr. Atencio, I understand we have an uncontested stipulation here, but I guess I would just, given what Mr. Monroy described, and he was clear, and I understand entirely why he would say it, he's not an attorney. I think for the commission's benefit, we would like to see that expand upon, and I'm not talking about a 100-page document. I'm saying if the company can, at the end of this proceeding, just explain what is being accomplished here in terms of the ETA requirements, what is the company required to do, and what does this Sunbelt project achieve? I think the commission would benefit from having some statement on the record as a matter of law. Here's what we've done, and here's how that fulfills our legal obligations. Can you do that, Mr. Atencio? Again, we're not looking for some tome. I think just having some clear articulation as a matter of law, what PNM is achieving by the Sunbelt project is essential for the commission to make sure it's understanding what's going on here and has clarity about what the company's position on its legal obligations are.
Yes, Mr. Hearing Examiner, we can absolutely do that. And just so I'm clear, what kind of time frame are you looking for a short statement to that effect?
As soon as you can. It shouldn't be an extensive project, so I don't think other than that there will be any briefing requirements. I mean, it is an uncontested stipulation, so all else being equal, I would just leave it to the company to get that submitted as soon after the hearing as possible.
We will do that.
Great. I recall with having meaningful discussions with Commissioner Ellison at one point, this is back to Mr. Monroy, about that 0.1 loss of load expectation as a standard. And I think Commissioner Ellison's perspective, if I recall from these discussions, was that, that's a sort of self-imposed target, and that necessarily imposes costs. And I think his concern was whether that was in fact essential for safe and reliable service, or was that sort of going beyond in a way that was just imposing costs for something that may not really be fully necessary for the ratepayers. Could you discuss that at all, Mr. Monroy?
Well, I'll give you my perspective. I think probably P&M Witness Dwayne is probably the more expert on why that's an adequate planning standard. Being a non-engineer, non-planning, my perspective, and at least the company's perspective is, we're here to provide service. And I think while there's no 100% assurance, right? I mean, that's a unattainable, or at least that is definitely an uncost effective way to plan your system. I think we have an obligation to ensure we set planning standards that, handle a variety of events and situations to make sure that we have enough resources to meet our customer needs. So at point one LOLE, I think that's probably Mr. Dwayne or even Mr. Wintermantle who, probably can provide a broader industry perspective on why that's a standard that's being adopted, by many utilities beyond just PNM. I don't think it's a PNM led level number, but from my perspective and my understanding, talking with, Mr. Dwayne and Mr. Wintermantle, that is kind of the new standard, especially as we move to the system is evolving and changing from, large generating resources and moving to more intermittent resources, that's an appropriate standard. I think that standard will continue to evolve as we continue here in New Mexico and across the country through the energy transition. But my understanding is that's an appropriate standard. It's not a excessive standard by any means that places undue untimely costs on our customers today. I think it's an appropriate standard for us to adopt and to really ensure our customers are able to receive electricity when they need it.
And then just for the record, I mean, I don't think this is in testimony, but just to make sure as we're talking, this is clear. That's the LOLE of 0.1 is 1 day with a significant load loss in 10 years. Is that sort of generally?
That's correct.
Yeah.
That's correct.
I mean, I think that it's interesting. I remember reading a news article about a utility in Texas, and their LOLE was 2.67.
Ooh.
Yeah, exactly.
Sorry.
No, that was my reaction too. I was sort of astonished, and I think it's when you hear the number 0.1, and I understand there are other reliability organizations that sit on top of all this and propose that as the standard. I do think that would amount to like 26 days every 10 years. Like that seemed pretty wild. And I tend to agree, right? Like as everything electrifies, we have an expectation that everything will just work all the time. But 2.67 struck me as unreasonable.
Yeah, Mr. Hearing Examiner, that would make me not sleep very well. I don't know.
Right.
That doesn't seem reasonable.
Yeah. So this question about the overall cost of the Sun Belt project and the CCSD, page 9 over to 10, you write, while the Sun Belt project is not part of the overall lowest cost portfolio to meet the expected 2028 need, the Sun Belt project results in the lowest cost portfolio that allows for forecasted load growth occurring sooner than expected. And I think what those words made me wonder is like, well, how much more expensive than the next best option is the Sun Belt project, right? As like if we were to say, well, if we're doing the Sun Belt because of whatever obligations we must, but if we did something else, here's what the cost of that would be. Was that mapped out at all?
I think PNM Witness Dwayne has a discussion in his testimony where they evaluated the Sunbelt project against, I think, a project located in the Navajo Nation, so not necessarily within CCSD, as kind of a cost comparison to understand, the reasonableness or the impacts if there were other projects that were bid into that RFP that could qualify. So, and I don't have the page, but I believe it is Mr. Dwayne has some MPVs where he did some analysis to a similar project that was bid in, but that was on the Navajo Nation. My understanding on the CCSD solely, but by far and away, it was the lowest cost in there. But I think there was also a Navajo Nation project that was evaluated as it was closer in overall cost.
Okay, so and I guess Mr. Duane would be the person to ask, and maybe he can review that further with me.
Yes, sir. I think he would be able to discuss that with you.
Great. And then if you're at page 11, you write approval of these resources will result in a LOLE of 0.064 days per year. And I'm trying to understand. So if an LOLE of 0.1 is 1 day every 10 years, 0.064 days of LOLE. Could you just explain what that number actually means in terms of like real time?
Sure. So if the 0.1 would be 1 day in every 10 years, this would tell you that the likelihood of that event is actually less than 1 day, and so it's, if you think 1 day, 2 days, 10 days, this would result in a reserve or a planning standard that would say it's less than likely that even 1 day in those would occur. So I think it just continues to minimize, or shows, the system could be pretty resilient. Within 10 years. We would expect not even less than 1 day we would expect to have an event.
And does that include, I'm just thinking yesterday we had a pretty interesting wind event. I mean, certainly here in Santa Fe, I believe I didn't lose power at my house. I lost internet. My mother-in-law and she did lose power. When those loss of load event numbers are calculated, does that count for stuff like what happened yesterday?
I think we're getting a little out of my expertise, so I don't want to just kind of make up something to you, Mr. Hearing Examiner. So I'd probably defer you to Mr. Duane or Mr. Wintermantle to kind of what goes into those loss of load events. Versus, I really don't feel like I'm qualified to answer that. I apologize.
Sure, that's fine. And I'm just scanning the testimony to see what other questions I have for you. And I think we've already covered this, but at page 22 in your direct testimony, and I'll just do it because I'll just make sure the record's clear about this. ESA costs 24,000,089 through the FPP CAC. That's, you say it 16 to 17. And then you point out if that's adopted, then P&M will also put the ESA costs, but based on the agreements in 24,000,089, that this is effectively withdrawn and P&M will collect the future costs through base rates.
Yes, sir, that's correct. I think in the testimony in support of stipulation also, I reiterate that kind of treatment, that's now the proposed treatment.
That's fine. I just want to make sure. I have my little questions here. I thought I'd just get a clarification. The cost overrun rule, I've not had a lot of experience working with that. Can you explain that a little bit? And then you talk about that at page 24. Just give me some sense as to what the practical impact of that is for these resources.
Sure. So the cost overrun rule basically applies to any facility when a CCN is granted if the estimated cost, assuming there's no contingency included in the certificated cost, which in the Sunbelt project, there's no contingency included in our certificated cost. So the cost overrun rule would say that if the actual costs run over 10% of the certificated costs, then the utility has the burden to present when it seeks recovery of that in rates to demonstrate why that's reasonable and why the cost overruns happened and are subject to review by the commission. So I think it's a customer protection that basically there's a certificated cost under a CCN that's granted. If the overrun rule is exceeded, and I think it's 10%, then the utility has the burden to demonstrate back to the commission why that overrun is reasonable and prudent.
Okay, thank you. And those are all my questions, Hearing Examiner Krankamp. Thank you, Mr. Monroy, for your discussion. It's always very thought-provoking. Appreciate it.
Thank you. Thank you, Mr. Hearing Examiner.
Good morning, Mr. Monroy.
Good morning.
I just have a few follow-up questions. And just because it's on my mind, I want to go back to a question that Hearing Examiner Ryan just asked you about the LOLE of 0.064. And he was asking to essentially to understand at a practical level what that would mean in terms of real time. If 0.1 is 1 day every 100 years, my interpretation of
10.
Yes, 1 day every 10 years is what 0.01 or 0.1 would mean. My understanding is that 0.064 would mean 6.4 days every 100 years. Is that fair?
Oh, you're testing, Mr. Hearing Examiner, you're testing my math skills. I think that math works out in my mind. Yeah, you're just changing the factor. So, I mean, I think that should make sense.
Okay.
I think that's a logical way of thinking of it. But once again, I bet probably Pnm Witness Wintermantle, who kind of does the LOLE studies, maybe be helpful to put it in a better context for yourself and the commission. I think to kind of how to think about that 0.064.
Okay, we can ask him that.
I guess I was thinking it's almost like you would expect out of every 10 years, a half day. And I know that that's not logical, right? Because you think of an event as a day, but I guess I was thinking it would be like, the likelihood of it happening is even less than 1 day. But he could probably confirm if I definitely checked your math, so I understand your logic.
Okay, we'll ask him that question. Do I understand from your testimony that today Pnm's LOLE would be 0.1?
That's our planning standard
Okay.
that we target. So when we file for resources and we seek to, get approval looking into the future, of course they're not a perfect set of assumptions, but you have a locked in set of assumptions of, what your forecast demand is, what your forecast availability of your resources are, and you can do the math to target a 0.1 LOLE. I don't necessarily know if based on today's demands, today's resources and what's available today, where our LOLE would stand. Maybe Pnm Witness Dwayne might have a better feel for that as they probably track it a little closer. But it's a planning standard that we reach to. So I can't I imagine at any given point in time, that number, the actual where we're actually achieving probably fluctuates.
Okay. And what is your planning reserve margin?
Like I said, we really moved to a 0.1 LOLE. My understanding that equates into a 16% planning reserve margin.
Okay. Now, one of the other questions I had was, I think this was in response to Hearing Examiner Ryan, you said that the alternative without these resources would be that Pnm would have to contract into the market to try to acquire capacity off of the wholesale market, which would obviously be a much larger cost to our customers. And my question, I guess, to that is, my understanding, and perhaps I'm wrong, but my understanding is that Pnm has been doing that very thing in the last few years. Is that correct?
That is correct, as the availability of the resources that were approved were delayed beyond their expected online dates. That's exactly right. We've had to go out and contract for capacity, and we try to limit it to the super peak hours, but a lot of times that product's not available. So we try to limit those costs, and we issue RFPs to get the lowest cost capacity as part of that replacement resource, or to make sure we have adequate resources for our summer peaks. And so we have experienced that, and our customers have had to bear the cost of ensuring there's adequate resources available. So that's exactly where that statement came from, is we've experienced it.
Okay. And can you explain why it would be obvious that that would be much more costly to ratepayers than building these resources?
I didn't.
These resources.
Sure, Mr. Henry, I apologize for talking over you. I didn't go back and look at the math, but I was trying to recall, and I think we've actually presented to the commission some of those contracts that we've had to do either through a workshop or through a special session. I can't remember, but I think we filed them. And my recollection of those is in 1 year, some of those costs were easily, north of, $20 million, $30 million. And so you think about that's providing resources over, 2 or 3 months for a very small window of time. Whereas these resources, that's a full year of value that our customers are going. And so that's just based on my recollection of what those replacement costs have been. Because you're buying a very peak time when everyone's needing capacity, right? And so that you're obviously having to pay a premium for that product to lock in that capacity. And then, so I mean, I think that's the big financial concern. I think that, comes first and foremost to mind. I think the larger concern is also that's if that capacity is available, right? You're kind of, and I think experience has shown it has been, which is great. You know what I mean? So, but you don't know what situations are going to be occurring in that moment and in that year where capacity can become scarce. And so I think not only there's a financial risk to customers that they would bear by having to acquire that capacity on the market, there's also just the inherent risk that is that capacity even going to be available to be contracted.
Right. Yeah, I mean, I remember these issues are somewhat familiar to me because I remember that they came up during the hedging case when that was approved last year. So I just thought I'd ask. One of the other questions that has come up, so the utility-owned resource, this would be the Sunbelt project in this portfolio. How does PNM anticipate that it would treat clean energy tax credits from that resource once it's online, if you know?
Sure. So clean energy tax credits. Here's what I do know and how we modeled it. We did model investment tax credits. Maybe that's what you're referring to by clean energy tax credits. I'm not 100% sure, but we expect to receive ITC on the battery portion of the Sunbelt project. We are estimating that ITC will be about 40% of the capital costs. The solar facility will also be eligible for production tax credits. That's also another tax benefit, and both of those benefits have been modeled in the revenue requirements that are included in my testimony before. So the expectation is they take advantage of those benefits. And I think I alluded to, and I think it was Chairman O'Connell, or maybe it was Mr. Hearing Examiner, I'm not sure. But that's, I think, one of the perspectives I think it makes sense to capture those now, why those benefits that were granted under the IRA still exist. I'm not aware of any change. I'm not trying to predict of where it's going, but I think current federal administration, I think there's a little bit of a risk on what federal policy is and what those incentives are. And so moving forward with these quickly can capture those at least known benefits today. And like I said, we've captured both ITC and PTC, investment tax credits, and production tax credits in the modeling of the Sunbelt project.
Okay. Okay. Let me ask you just a little bit about your about the stipulation, and I had just a few questions about this. So can you walk me through, just for the record, essentially the changes between and the differences between what the commission would be approving in the stipulation and then what was originally proposed by the initial application? My understanding is that the major differences would include the rate recovery for the ESAs, and then possibly the 20 megawatt storage bid enhancement for the Sunbelt project. Is that a fair summary of those major differences?
Mr. Hearing Examiner, I think that's fair. In large part, the stipulation kind of memorializes or adopts the application as we filed, because the application itself also included the 20 megawatt increase to move to the 50 megawatts. I think what the stipulation provides are the two things you do. It kind of memorializes the recovery of the ESA treatments, just as we've progressed in other cases in there. The only other really kind of provision that wasn't in the original testimony was probably in paragraph, I'm trying to find it, give me 1 second, paragraph 34 of the stipulation. And really, I mean, that's not necessarily new kind of practice, but it kind of memorialized if there are amendments to the contracted resources, kind of what the review period would be. I think that that 10-day review period has been issued in previous commission resource cases of, if there's amendments to the resources, Pnm file makes a filing, and parties have 10 days to review that, and if they so want to, discuss it or object, they have that ability. So I think that's the only other kind of new term that is with the stipulation, other than what you identified, that it really memorializes the signatory support for moving the Sunbelt project up to the 50 megawatts, and then how the ESA costs will be treated similar to how they are in the rate in the 240089 case.
Okay. Let me ask you about one other note that I made. And this may be standard language in these stipulations, I don't know. But you flagged it in your testimony. If you look at the bottom of page 15 of your stipulation testimony, so this would be Pnm Exhibit 2. You say, moreover, the stipulation makes clear that the outcome of this proceeding is not intended to have precedential impacts relating to the standards applied in future resource acquisition cases. Can you tell me why that's important and why you flagged it in your testimony?
Sure, and I can speak to that, Mr. Hearing Examiner. I think there was concern from the parties that a new standard wasn't being created on how the commission should approve resources. And so I think it goes to kind of, treatment of, from Pnm's perspective, the ETA locational requirements didn't necessarily apply as a standard for the commission to adopt or approve this resource. And so then if you have that perspective, I think there was concern that, are we creating a new standard, a new long-term standing practice of how resources are evaluated and approved by the commission? And so I think the stipulation is intended to, there's no precedential effects, so there's no new creating a new standard of how resources may be evaluated in the future. And so it's kind of memorializing and providing that protection.
Is that related at all to what I interpret here, which is that this particular portfolio isn't the lowest cost overall, but it is the lowest cost within CCSD? Is that what that provision is getting at?
Mr. Hearing Examiner, you said it much more succinctly than I did. Yes, that's exactly right. That if it was a litigated out, or if I think the settlement protects that some parties' concerns, that the commission would create a new standard for not the lowest cost portfolio. So.
Okay. Let me ask you about one other item, unless I remember anything else. Let me ask you about, and I don't believe that Hearing Examiner Ryan asked you about this. If he did, my apologies for duplicating the question. But if you look at page 10 of your stipulation testimony, so Pnm Exhibit 2, talk a little bit about tariffs. Tariffs in this utility context can mean a number of different things. I assume we're talking about tariffs at the federal level being imposed on foreign countries. You talk a little bit about the impact of potential tariffs and Pnm's concerns there. Can you expand on the potential impact of tariffs on Pnm in particular?
Sure. I mean, I think it's just a global concern that, in the current environment, if tariffs are imposed, then that may impact the pricing or the availability or the, just it's a concern on both the developer side and Pnm side to make sure that the materials can be ordered, they can be delivered. As those tariffs, have exposure, they have price exposure to either the developer, right, to cover those costs, or how they're going to be managed. And so I think, and I did, what I saw with Mr. Hearing Examiner or Mr. Ryan, I think diversification is really the key that we try to look for, right? And so, I think the purpose of this is to identify to the commission that, GridWorks is a New Mexico company, that they use a diversified supply chain, so they're not necessarily beholden to any one country. They have facilities outside of China and things like that to kind of mitigate if there's an environment where situations change on the tariffs. So that's kind of what I was just trying to get at, trying to disclose that really diversification is your best ability to mitigate that risk, right? I mean, like I said, we're all about risk mitigation. I don't, risk avoidance isn't really all that, practical, but risk mitigation is a very key aspect of what we try to do. And so just trying to give a little bit of, for that specific project, using a local contractor who has a diversified supply chain to give the commission some comfort that we are looking and monitoring that risk.
Okay. Thank you. I don't think I have any further questions for you. I appreciate your testimony this morning. Hearing Examiner Ryan, Chair O'Connell, any follow-up questions? Okay.
The only
Oh, go ahead, Hearing Examiner Ryan.
Commissioner O'Connell, go ahead, please.
Sorry, I was fumbling with the mute button. No further questions from me. Thank you.
Yeah, the only thing, Commissioner O'Connell, I would, we had a discussion there, and let's call the request to provide the more granular data about bill impacts, like bench request 1. And then during that exchange, Commissioner O'Connell, you indicated that there would be some questions for staff on that subject. We're here on an uncontested stipulation where there is no staff testimony. So in that regard, I think, we could have the discussion at any time, if you wanted, for instance, to produce bench request to staff to explain, how did it evaluate these resources without if they had the information about the granularity of detail, and if they didn't, how did they determine? Like, that would have to be asked in sort of not in a witness questioning context, because we don't have a staff witness here. If you follow my thoughts there, Commissioner O'Connell.
Yeah, I understand. And so I guess for me, there was 2 questions there. One is just support of the stipulation was, how was affordability or customer impact on cost considered? And, picking on staff isn't exactly fair. Same question for Department of Justice. So maybe, I don't know what the best way to format that is. And then the other one, and Mr. Monroy talked about it a little bit, was just what does staff see as the primary use for battery? Is it storage? Is it energy arbitrage? Is it something else? What are the important secondary uses for batteries? And then does the various pricing that's available on batteries, we've got utility owned in this case, and dollar per megawatt hour, how do those mechanisms support optimizing the primary use, or do they provide a perverse incentive to somehow not use these batteries in a way that's best for customers? So that was just a curiosity question for how does staff see these pricing provisions. It isn't just, testimony's been about base rates or fuel clause, but I'm also interested in making sure these devices are deployed in a manner that's best. So does pricing matter in terms of regulatory question of, is the incentive aligned with what we need?
So I think the thing to do would be to call that bench request 2 and to direct that bench request to PNM staff and the Department of Justice, and have them submit testimony on those subjects to the extent to which they can, and feel that testimony adequately responds to those questions. And we'll have the transcript, so you can go back and see what Commissioner O'Connell said. And the time will be allowed to, obviously for the transcript to come into existence and then folks to study it. But then we'll also just effectively tell those 3 parties, PNM staff and the DOJ, the Department of Justice, to answer in as quick a fashion as possible. And, of course, the DOJ elected to not attend today. So we'll have to figure out a mechanism to inform them. It might just be simply an email or some sort of order on the record. I don't know. Hearing Examiner Cryan-Kemp and I'll figure that out.
The only other note I would make, DOJ also doesn't have a witness in this proceeding. So how we phrase the bench request to them might be slightly more nuanced than to PNM
Yeah.
staff.
Well, and my view would be that, that's yeah, that does present problems, but apart from saying inquiring minds want to know, that's what these whole proceedings are about.
Yeah, and
So-
then I identified those parties just as the ones that I expect to have a position on those topics. And your point about we don't have a witness is something I hadn't thought about. And then I also didn't want to exclude anybody else who wanted to opine on topics because I know affordability is key for NM area and other parties also. So just because I picked those three, I didn't want to
Yeah, no, I understand the point.
exclude the points of views of others.
Well, and then I think effectively we can just extend it and say that anybody wishes to opine on the subject can. They are all stipulating parties. So they all have the capacity to provide testimony if they so wish. And if they decline to do so, then, the commission understands what that means too. But at the minimum, asking PNM, the DOJ, and the staff to supply testimony as a requirement gets you, at least some guidance on the subject. And then everybody else has the opportunity to contribute testimony if they so wish. Does that make sense?
Yeah, thank you.
No
This is
problem.
why O'Connell doesn't do his own hearings.
No, look, I think ultimately the question about, this is where you start the discussion with Mr. Monroy about what is the actual impact to ratepayers. I think, that's a really important question that oftentimes is sort of just, I don't know, it's not missed. I wouldn't say that, but we can't gloss over it. So I'm glad that you're there. I'm glad you're asking these questions, Commissioner, and they're perfectly appropriate. And then basically the question becomes, how do we create the mechanism to satisfy the curiosity? And that's not too challenging. And these are all professional parties who can do whatever they are inclined to supply.
Ms. Lynch, you had your hand up.
Yes, hearing examiner. Thank you for taking a question. I believe this is in the purview of the questions and the topics explored by you and the commissioner. I'm curious about the ITCs, the tax credits and the production tax credits, and the stability of those potential tax credits with impacts that PNM could incur or PNM customers could incur. I don't know if this ventures into speculation. I am just curious about that area.
Just to clarify, Ms. Lynch, are you looking to ask this question to Mr. Monroy?
I am wanting to ask this question, does okay. Anyway, what is PNM's perspective on the ITCs and the PTCs, and are those stable for these projects?
I had that question too, Ms. Lynch. So go ahead.
Go ahead and
thank you,
answer,
Ms.
Mr.
Lynch.
Monroy. Yeah.
Yeah, and go ahead. Yeah, exactly.
No, thanks for the question. So, I think a little bit of speculation does start to play in. Currently, the IRA is the law of the land. Currently, the Sunbelt project both qualifies for a 40%, what we're estimating to be a 40% ITC credit for the capital construction costs related to the battery. And the 100 megawatt solar facility qualifies under the current IRA to receive production tax credits as well under those tax benefits. So, there, like I said, I'm aware of no legislation. I'm aware of no changes that would put those at risk today. My comment is more just reading the paper and just being aware of the environment that the federal government's operating under. And so I think as with everything, right, you have to just kind of be aware of certain things and just you'll deal with them. But I'm not aware of any proposals. I wouldn't even know if the IRA's changed, if those would be grandfathered in. That all begins speculation. So it's really not, I don't think, appropriate to speculate. I think it's just being mindful of the policies that we all are tracking and being aware of.
Any follow-up, Ms. Lynch?
No, sir, that answered my question.
Okay, excellent. Hearing examiner Ryan, any follow-up on that?
Thank you.
Okay. At this point, Mr. Atencio, do you have any questions on redirect, sir?
No, Mr. Hearing Examiner, no questions for redirect.
Okay, thank you. Okay, so seeing no further questions, Mr. Monroy, we greatly appreciate your testimony this morning. Thank you for being with us.
Great. Thank you, everyone. Have a good morning.
And with that, I think it's time to take our morning recess, a little later than we intended, but at least we did get one witness done. So we'll go ahead and be on break until 10:30. And with that, we're temporarily off the record. Okay. Good morning again, everybody. Okay, so we now have, looks like everybody's back. The time is now 10:34, slightly longer break than we anticipated. Before we go much further, hearing examiner Ryan just wants to address that second bench request that we had talked about.
Yeah, no. So I just want to make clear, when I was speaking earlier, the Darren Zigich is the witness for staff, but my understanding of Mr. Zigich, having met him several times in the commission and worked with him in other cases, he comes from the engineering background. And the point was ultimately when we're talking about rate setting and how the costs of this are likely to be absorbed by ratepayers, that's sort of a different set of concerns, which was not addressed really, apart from the P&M testimony and identifying what the revenue requirements are. So I think it's important that we have, as we discussed earlier, the three parties who are obligated to answer bench request 2 as articulated by O'Connell, answer those, and then everybody else can supply them. We will have an opportunity to ask Mr. Zigich about some of the costs and the operation of the batteries. But I think ultimately we will find that the answer about what is the rate impacts is in fact a question we don't have answers to at this juncture from anybody. And obviously P&M is going to supplement with their answer to bench request 1. I think I've said enough there.
Okay. So Mr. Rossi, for the purposes of bench request 2, we're going to provide you just a little bit more clarity about that after Mr. Zigich has testified. Okay.
Thank you. I was going to ask for a little bit more clarity, so let's move through.
We will do that as soon as your witness is finished. Okay, so with that, over to you, Mr. Atencio, to call P&M's second witness.
Thank you, Mr. Hearing Examiner. P&M calls Thomas Dwayne.
And Mr. Lee, if you'd please swear in the witness. Looks like he might be having a bit of video difficulties right now.
Yes, I'm here. It was working for a second. It seems to have quit.
No problem. If you want to try turning it off and then maybe turning it back on.
Yeah, I mean, I was having the same issue earlier, and it was the actual port. If you have a machine where you can plug your, unless it's your built-in laptop camera, try a different USB plug or pull it out and then plug it back in.
Mr. Hearing Examiner, I understand our IT folks are working on that for Mr. Dwayne, so if you could, we could beg you for just a minute to get that fixed. We should be up and running shortly.
Absolutely.
Mr. Hearing Examiner, Shane Early for Bernalillo Solar. I would also ask if I could be excused later, and we did not plan on asking any cross-examination questions.
Absolutely. That request is granted. Thank you, Mr. Early. There we are. Looks like camera issue may be fixed. Can you hear us, Mr. Dwayne?
Yes, I can hear you. Can you hear me?
Perfect. Yes, we can. So I think at this point, Mr. Lee, I think we're ready to swear in Mr. Dwayne.
Mr. Dwayne, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir.
Go ahead, Mr. Atencio.
Thank you, Mr. Hearing Examiner, and thank you for your patience.
No problem.
Mr. Dwayne, would you please state your name and job title for the record?
I'm Thomas Dwayne, and I'm Director of Pnm's Integrated Resource Planning Department.
Do you have before you what's been labeled as Pnm Exhibit 5?
Yes, I do.
What is this document?
This is my direct testimony submitted in the filing.
Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, it is.
Do you have any additions or corrections to it?
No, I do not.
If I asked you the same questions today, would your answers be the same?
Yes.
Mr. Hearing Examiner, I would move admission of Pnm Exhibit 5 into the record.
Okay, thank you. Per the stipulation, there's no objection from the signatories. Any other objection to the admission of Pnm Exhibit 5? Seeing none, Pnm Exhibit 5 is admitted into the record.
Thank you. And that's all the questions on direct I have for Mr. Dwayne. Would make him available for any other questions.
Okay, thank you. So at this point, cross-examination has been waived. So I turn first to Chair O'Connell. Do you have any questions for Mr. Dwayne, sir?
Great, thank you. Good morning, Mr. Dwayne.
Good morning.
So you have my old job, huh?
Yes.
Be careful what that leads to. That's all I got to say. So I just have like one big question for you. What is, Pnm's represented these resources important for reliability in 2028, especially summer peak. So does Pnm have a plan B if the resources aren't online by then?
I would say we have not really looked at a plan B. If they're late, we would potentially continue current practices of if we end up deficient in 2028, we would probably still be looking at going to the markets then to try to cover those deficiencies.
Yeah, I mean, I'm asking these questions just from a place where I've seen the industry struggle to get things online. And so the follow-up to what if doesn't happen is how soon would PNM have to react to get something going for the summer of 2028 to maintain reliability if these aren't succeeding?
PNM would probably start looking at least a year ahead if it looked like these were going to be delayed at where we could acquire power from the markets and see what they could shore up for us in 2028.
Thank you. And thank you, hearing examiners. That's my questions. And best of luck to you, Mr. Dwayne.
Thank you.
Thank you, Chair O'Connell. Hearing Examiner Ryan, any questions for Mr. Dwayne?
Yes, I'll start with the matters Mr. Monroy deferred to Mr. Dwayne. Mr. Monroy and I were having a discussion about the 16% planning reserve, which is effectively a 0.1% LOLE. The planning reserve percentage margin stems from the attempt to achieve a 0.1 loss of load expectation probability. I guess that's what we'd call that. So the question for Mr. Monroy was, is that necessary, the 0.1? And I'd noted the fact that in previous hearings, former Commissioner Ellison had asked questions about the cost of doing that and whether that's something that's necessary to provide safe and reliable service, or if that, shooting for that target ends up costing the ratepayers more than they would need to pay. So if you could address that, Mr. Twain.
We certainly don't believe it would cost more than they should otherwise pay. We attempt to use what's largely become an industry standard across many utilities, including some of our neighboring utilities. RTOs, we see that 0.1 LOLE used in forums like the Western Power Pool as they're designing some of the resource adequacy programs. So we believe we're sticking with really what's being used as an industry standard for acceptable reliability in the resource planning arena.
Okay. Another question I asked Mr. Monroy, which he deferred to you, was about the Valencia plant and what is the explanation for what seems to be a bit of a U-turn on the future use of that plant. If you can address that, I'd appreciate it.
Yeah, I don't have the full privilege of previous discussions on Valencia or some of the earlier resource planning analysis. I've been in this position for a little over a year now. But I do believe that one of the big drivers in those changes was the fact that the trends in renewable energy were forecast to be significantly cheaper than they've become today. Prior to COVID and even into the first year or two of COVID, with supply chain issues and other things, we've seen those costs increase substantially. And that's going to work in favor of a gas-fired power plant that's already existing and not needing to go out on the market to acquire new equipment. So I would see that the cost of renewables going up has been a big factor in why Valencia is now much more favorable than it looked like in analysis several years ago.
Okay, and then if I understand correctly, Valencia, the type of plant that it is, startup and ramp times are pretty significant. I mean, I did see in the testimony there was some indication that it can go to full capacity in some relatively short period of time, but it was my understanding that as the ramp times for that particular plant are quite extensive, and that partly explains was it like $8,000 per start just to utilize the unit. Is my understanding of that correct?
The ramp times are fairly favorable for a gas CT, which is why we have it as a quick start unit. It can be online in 10 minutes and start ramping. I believe that the start charges is that when you do quick starts, it puts a lot of stress on the machine, which tends to drive the need to do maintenance, work more quickly. So there tends to be a fairly steep penalty in terms of just the impact of the machine itself when you do quick starts on them.
Yeah, and that I think kind of goes to the question of where it was Valencia was, as a gas, and I suppose maybe what you're indicating there is that the utility doesn't perceive using that facility as a peaker plant, but more for sustained baseline. Or maybe you can clarify what's the projected use case for the Valencia plant?
I think we see the plant as heavily used for contingency reserves and responding in short-term efficiency situations. They don't come up too often, especially to the extent where they actually require you to do a quick start. So it's pretty rare that we would actually see those kind of quick start charges or stresses on the machine. So it stays there available for providing capacity in situations where resources become short. But it can be started fairly quickly if that does happen in an unpredictable or fairly short time frame.
With that contract for Valencia, I'm just trying to make sure I understand how it'll be used and what the costs may look like. If it's a PPA, I guess I always sort of assume that those costs are built into the amount of use that gets generated. But is that can you just generally explain given what you've just said, how is it that, like, if the plant is simply being used for contingency reserve, then what downstream costs are the customers likely to, the ratepayers that is, incur as a consequence of the continued use of Valencia? Like, if you don't use the plant, you don't need it for a contingency basis. I mean, how does Valencia continue to operate, right? If I'm just trying to understand broadly how it works.
I would probably direct that question to Mr. Barnard. But the plant, the PPA does have a fixed demand charge that gets paid every month.
Okay.
As part of the plant cost. And then when it does operate, there is energy costs that we pay for fuel and for operations and maintenance that are covered in the PPA. There are startup charges that are in the PPA for each start on the unit.
But if it is being planned as a mostly contingent use facility, I mean, in an ideal world, does that mean the plan is for it not to run, or would that be too aggressive of a statement?
If you don't run it, you're not going to incur as much in the energy charges or the startup charges. So those would be pretty much as you run it type charges that are incurred. The demand charge will always be there, regardless of whether you run it.
Another question I asked Mr. Monroy was about the self-build for the Sun Belt project and why that was the only of the three, or the only self-build proposal here. And he directed me to defer to you a question about why that was the case. Can you shed any additional light as to why it is the Sun Belt project is a self-build project versus the PPAs that you otherwise were asking for here, ESAs and PPAs?
My involvement is largely in phase 3 of the evaluation. I do believe there may have been some utility-owned gas bid in the early phases, but it did not make it to the phase 3 evaluation. The Sunbelt project was the only self-build project that was introduced into phase 3. And there was a very limited number of projects altogether. Mr. Nagel could probably clarify just what that was. Introduced it, provided bids at all into the process.
I asked Mr. Monroy about the loss of load expectation and the type of wind event we had yesterday, and whether the LOLE figures capture the type of events that happened yesterday for some portions of Santa Fe. Can you shed any additional light on that subject?
The LOLE reliability criteria almost exclusively applies to resource planning. It implies a certain amount of reserve margin. The type of events you typically see in a wind situation are not resource shortages. They're typically driven by transmission or distribution outages.
Okay, so generally, when we're thinking about LOLE, the disruptions that we would experience from natural phenomena, be it wind, fire, whatever, are not embedded into that reliability metric. Is that correct?
The transmission and distribution outage criteria is not embedded in that criteria.
Okay, so it's purely just examining from a resource adequacy perspective. Having this much resources guarantees us this much reliability.
Correct. It's to ensure you're not turning customers off because you've run out of resources.
Okay. Just switching over to your testimony here. Those are all the questions I had for Mr. Duane, hearing examiner Krankamp, so feel free to proceed with your own questioning.
Okay, thank you. Good morning, Mr. Duane.
Good morning.
I just had just a couple of follow-up questions. I think most of my questions are asked and answered, but want to ask you just a little bit about the question that you were asked on page 17 of your direct testimony. So this is PNM Exhibit 5, page 17. You were asked about long duration storage resources analyzed in Pnm's phase 3 evaluations. And you said that storage options submitted to PNM in the RFP process were limited to 2 and 4 hour BESS. And I just want to make sure I'm understanding this answer right. My understanding is that essentially as part of the RFP process, there were no bids submitted for long duration storage options.
That is
correct?
Yes, that's correct.
Okay. Is there a significant price difference between 2 and 4 hour BESS and long duration storage resources?
I don't know that the price difference is the bigger driver. Long duration storage right now is technology that is not clear what it's going to be or readily available in the market. There's some pilot projects going on with things like iron air. I would expect those are quite expensive at the pilot project phase, over 2 to 4 hour batteries. But the real issue is, are there truly viable long duration storage options available in this time frame? And I think that's partly why we see no bids, is that people are looking at the time frame and they don't believe they can provide a product that meets that long duration storage requirement.
Okay. Now, another question that I had, you're asked this question, this sort of goes to the question the hearing examiner Ryan was asking you about the Valencia PPA. You're asked this question on page 18 of your testimony about how the Valencia PPA fits within the ETA transition to clean energy. You talk about how the plan is to use this to ensure reliability, essentially, I think to ensure sort of reserve margin, if I'm understanding that correctly. My understanding is that the PPA that you're proposing in this case would expire in 2039. Is that correct?
That's correct.
Okay. And so that would be basically immediately before your 2040 goal, Pnm's 2040 goal of being carbon free?
Correct.
Okay. So it would be the expectation essentially that you would not essentially need to renew that PPA then, assuming that the transition occurs as planned. Is that a fair assessment?
I would say an answer to that is probably subject to a future resources assessment. But under the current technology, it's assumed that it wouldn't be a viable option because it would still be a carbon-based resource. To the extent that the facility can be modified to not be a carbon resource, there's a potential it could be a new PPA that was still associated with that facility.
Well, and let me just follow up on that, because I think, and I can't be sure about this, Mr. Duane, I have to go back and look, and I will. If I recall correctly from the 21-215 case, again, that was the Palo Verde replacement resources. Mr. Falgren one of his perspectives as to why Valencia was in his testimony in that case at the end of the batting list was because unlike some of the more modern turbines, I believe, I'm sure I'll get these slightly wrong, like LM 6000 or whatever he described, similar to a Boeing 747 jet engine. Those type of turbines can be readily converted over to utilize alternative fuels other than methane emitting natural gas, whereas Valencia, given its vintage, really cannot be converted. And I don't know if he said during the course of that hearing it cannot be, or if it would be cost prohibitive to do so. Do you have any understanding of that matter with any depth right now?
No, I think your understanding is pretty accurate there. That's why I say if it could become a carbon-free resource, and that's not a given. It's absolutely not a given with the current technology there for sure.
Okay, thank you.
And Mr. Duane, I don't believe I have any further questions for you. I think you've answered all of mine. I do appreciate your testimony, though. Mr. Rossi, you have your hand up, sir.
I do have rebuttal based on your questions, if that's all right, and if now's the right time.
Well, let me go to Mr. Atencio first and just see if he has any questions on redirect, and then I can come back to you and then back to Mr. Atencio. Mr. Atencio, any questions on redirect at this time?
Mr. Hearing Examiner, I did have a couple, but I'm unclear what the rebuttal would be, and might ask if these are going to be any kind of questions asked of Mr. Duane, if I could do redirect following that.
Yes, that's fine with me. Mr. Rossi, I mean, cross in this circumstance is unusual because you're a signatory. I'm going to indulge your questions just for a bit, subject to any objection from Mr. Atencio, but go ahead.
I don't have very many, but Mr. Duane, I don't believe we've ever met before. I'm Nick Rossi, attorney for PRC staff. Thank you. When it comes to Valencia, within the 2028 forecasting, are you forecasting to run Valencia at all in 2028?
We would expect it to run very little. If you get into the right renewable patterns where you end up with very low resources in that period, you might, but more likely it would run for transmission contingencies where we needed to deal with maintaining the transmission reliability. And that's a significant part of its historical operation. The day-to-day dispatch of it tends to be primarily limited to summer peak, and it can sit for days on end without being operated.
And what about for La Luz, Reeves, Rio Brava? Are you forecasting any of those through the 2028s, similar to Valencia?
Pretty much the same answer, that we would expect them to run only during periods where we might see any extended resource shortage, and that they would almost certainly run some for transmission outages to maintain the transmission reliability. The dispatch statistics on those in that 28 timeframe are extremely low.
Okay, thank you. Those are the only questions I had, and I hope they help to answer hearing examiners Ryan's questions. Thank you.
Thank you, Mr. Rossi.
Yeah, and it does. It prompts. I mean, I'm not trying to. I don't want to go into endless back and forth, but I guess one of that hearing in 21-215 and the discussion of the Valencia facility was one of the most remarkable hearings that I've had at my time in the commission. And effectively, what happened was Mr. Throne, who was counsel for, I believe it was Onward Energy, who was representing the Valencia facility there, really took issue with the utility's decision to abandon, proposed in the IRP to abandon Valencia. And my understanding was, it would become merchant plant and effectively have, if P&M stops using it, then it's sort of dead in the water. And I think the concern that was articulated by P&M in their IRP was this plant is not a worthwhile expense. And so the question became, should the company continue supporting it, what I'm hearing you say, Mr. Dwayne, is that you're basically going to keep it, you're going to pay some money to the owners for purely contingency reserve purposes. And I guess my the ultimate question I want to make sure I understand and an answer to, and a clear one, is like, why should the ratepayers do that? Why should they be obligated to pay these costs? And how can the commission be certain that in fact Valencia is a good investment?
I think if we look at the reliability requirements of the system, and if we took those plants out, we would be looking at finding alternatives to restore the reliability to what it needs to be. So while those plants don't run a lot, they do fill that couple of days a year, maybe a little bit more, where other resources are not able to serve the load, and those ones are available to operate for those time frames. If you don't have that, you end up looking at what other resources would you put in to cover that.
If I go into the record, can I find what it is that the PNM pays to have that resource as an existing resource for it?
Yes, and Mr. Barnard should be able to help you with the cost of the Valencia PPA.
The anticipated cost to have it in the capacity you intend to rely on it for?
Yes.
Mr. Barnard.
If I
Okay. Yeah, I think you do. I mean, basically the question is what is the, I understand what you're saying it's going to be used for, and then the question becomes, okay, well, what is the cost of that status, and, just understanding what that means for the broader questions of, affordability and what is it the ratepayers pay? Mr. Barnard would be the person to ask. Is that what you're saying?
Correct. And I do believe that also in Mr. Monroy's testimony, there's a table that shows the expected annual revenue requirement for the Valencia facility.
Okay.
And that cost is probably reflecting a cost that's continuing from today. It may be adjusted a little bit. Mr. Barnard could put perspective on that.
Okay, thank you.
Mr. Atencio, questions on redirect.
Thank you, Mr. Hearing Examiner. Mr. Dwayne, just a moment ago, you mentioned alternatives, being forced to look at alternatives regarding if the Valencia and other similar plants were not there. Could you tell me a little bit more about what those alternatives might be?
They would be very similar to the same things we looked at in determining this preferred resource portfolio. It would be things that are similar to the bids we would expect. In fact, one of the questions in this whole analysis is whether the bid we received to maintain Valencia was really the best bid out of all the ones we received, or one that fit in the preferred portfolio. And the analysis showed that the bid was in there. If it had not been one of the preferred ones, we would have been selecting something else that was bid into this RFP.
Okay, and so those sound like a little bit more longer term alternatives, things that might require construction and development. Is that correct?
That is correct. It would probably, high probability, it could be additional battery and solar, because those are the most readily available resources for this time frame at this point.
What would be a shorter term alternative?
The shortest term alternatives this close are probably going to be going to the market, looking at additional market purchases if you don't have the capacity to meet your reliability criteria.
Okay. And a little bit further back, you mentioned being involved in phase 3 of the RFP process. Can you just briefly summarize what was phase 3 of the process?
So phase 3 of the process, the RFPs has 3 phases in it. There is a large number of bids typically submitted in, and they go through phases 1 and 2, and then a relatively small portion of those actually get passed into phase 3. In phase 3, what we do is we take those bids and we take what we call shortlisted. The ones that are shortlisted go to the phase 3 analysis. We take those, run them through models to determine the most cost-effective portfolio to meet the reliability requirements in the 28 timeframe.
Okay, thank you. And Mr. Hearing Examiner, that's all the questions I have on redirect.
Thank you. Mr. Dwayne, your answer to one of Mr. Atencio's questions leads me to one quick question. He was asking about essentially the Valencia PPA and the alternatives that PNM might be forced to look to, essentially, if that was not approved. And you talked a little bit about additional battery and solar. My understanding from thinking this through and from looking at the testimony is that one of the advantages of the Valencia PPA is that because it is a gas, it is a gas facility. It has certain advantages in terms of ensuring reliability during peak load hours that battery and solar might not have. Is that correct? I mean, am I looking at that correctly?
Yes, I think that is correct. And one of the things we're seeing is those hours where battery and solar covered well are being extended as load is increasing in this time frame. They also end up being extended anytime we retire a traditional thermal resource.
Okay.
So 4-hour battery works well for a period. Because alternatives are somewhat uncertain, to longer duration storage, what comes out on top tends to be gas generation at the moment. Start covering those longer periods that we're seeing.
Right, and so that's I guess where I'm confused. If that is one of the advantages of the Valencia PPA, which makes sense to me, in 2025, that you testified earlier that long-term battery storage really isn't on the market right now, and available to PNM. Why is it then that if Valencia wasn't approved as part of the portfolio, that you would look to battery and solar to replace that and sort of fill that void?
You can still fill the void with battery and solar, but the cost may be getting fairly prohibitive. What we see in the models is that they're tending to use 4-hour batteries and add them in a way that buys you 6 hours. But that's pretty cost prohibitive.
Okay. Okay, I think that makes sense. Hearing Examiner Ryan, any follow-up on that? Okay, and then Mr. Atencio, it's your witness. Did you have any final redirect?
No, thank you, Mr. Hearing Examiner.
Okay, thank you. With that, Mr. Dwayne, thank you very much for your testimony. We do appreciate it, and the time you took to be with us today.
Thank you.
And that brings us back to you, Mr. Atencio. You can call your third witness.
Thank you, Mr. Hearing Examiner. PNM would call Mr. Gary Barnard, and if you just give us a second, we'll get him set up in our witness room.
Absolutely.
Thank you.
He must have gone to the left.
Yeah,
Is that what he did? Yeah, if you're not centered fairly well.
I think you told me.
Yeah, you're really still, man.
I know.
Okay. Hello, Mr. Barnard. Just FYI, you are not on mute.
Yep, we're ready. I'm ready.
Okay, perfect. Mr. Lee, if you would please swear in Mr. Barnard.
Mr. Barnard, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, nothing but the truth?
I do.
Thank you, sir.
Go ahead, Mr. Atencio.
Thank you. Mr. Barnard, will you please state your name and job title for the record?
Gary Barnard, Executive Director of Renewable Generation and Contracts.
Do you have before you what's been labeled PNM Exhibit 6?
I do.
What is this document?
It's my testimony in the contracts.
Was this prepared by you or under your supervision?
It was.
Is it a true and accurate account to the best of your knowledge?
It is.
Do you have any additions or corrections to it?
I do on my testimony on page 11. I think it's line 4 or 5. It asks about the gross receipts tax. And it should say, no, not.
Just for the record, I think that's page 14.
Page 14, yes, sorry, I got that wrong. Page 14, line 5, line 4 and 5. At the end, it says the project was not included with the EPC contract. Gross receipts tax for the project was not included.
Thank you. Do you have any other corrections to your pre-filed testimony?
I do not.
Accounting for the correction, if I asked you the same questions today, would your answers be the same?
It would be.
Mr. Hearing Examiner, I would move admission of P&M Exhibit 6 and note that the correct version was uploaded to Dropbox.
Thank you, Mr. Atencio. I do see that. Per the stipulation, there was no objection from the signatories. Any objection from any of the other parties as to the admission of P&M Exhibit 6? Seeing none, it's so admitted.
Thank you. And that's all the questions I have for Mr. Barnard. I want to present him for any other questions.
Okay, thank you. Going first to, again, cross-examination having been waived. Going first to Chair O'Connell.
Thank you. Good morning, Mr. Barnard.
Good morning, Chair O'Connell.
A long time no see, huh?
I know, it has been. Have you recovered from the Lobos blowing that lead against Michigan State?
They're dead to me. So I don't know, were you watching when Mr. Monroy testified?
I was.
Yeah, so you agree with him that you demand in terms of getting these resources online in time?
Yes, we're gonna manage that process. I mean, part of it is this stipulation is incredibly helpful to that. If we can get this approved sooner than September, we'll give notice to proceed. You know, I was hoping this month so we can get them started. They can order things, hoping to beat tariff and tax issues as well. So and get them going earlier is always better.
And then can you, I mean, do you still agree with the expected availability dates or that are in the stipulation? That's January 15th for Sun Lasso of 2028, end of year for Core Zone of 2027, and Sunbelt May 5th or May 1st, 2028.
Yes. Correct. Sunbelt should be completed by the end of December of 2027. And we've already been in discussions with them to move up the date if we get a decision by the commission sooner so that we can give them notice to proceed sooner. So we're going to, you know, we want to be totally online by the end of 27 or sooner.
Okay. And then, you know, here in the commission decision is important in this, who has the ability to decide when P&M asks for a decision from the commission?
I'm not sure what.
Well, just trying to thinking about it as a Gantt chart and rate limiting steps. If commission decision date is important for getting them online for summer 2028, who decides when to start that process?
Well, we would start once we get a positive commission decision. We'll give P&M, we'll provide notice to proceed for them to start their work because they'll know that the project now is a go.
Yeah,
so,
I was thinking more in how did P&M decide when to file for approval of these resources?
Oh, how they set up the model before, I can't really address that question, but I mean, we're still planning if we get reg approval by September. I think that was in the original schedule because when we filed, worst case was September, that we could still make it. It's just, as you know, and you're building a schedule, you want to create as much flexibility as you can to make it. But it's structured so that they can make it, even if we give them reg approval in August and September.
Okay. And then did you have a similar role with the Rockmont project as you're going to have with the projects in this filing?
No, I was not involved with any of the earlier projects that P&M had. I was working in the finance group with a joint venture that PNMR had at that time. And so I wasn't involved in any of the management of the contracts before. That's a new role that I've just taken over since January.
Okay. And I mean, reason for the question is any lessons learned from there that will be instructive as you're trying to get these resources online?
Yeah, we've done a couple things associated with that. Obviously, if you can see, the delay damages are much higher in the contract than they used to be. We have a dedicated contract manager now that goes out and checks on a monthly basis where they stand on how they're moving with their schedule. We review their schedules with them monthly to see where they are. So it's not the same type of, I think, where we gave them some flexibility associated with how they do their work. We need to know soon if there's going to be any issues with them. I think they understand as well, if they don't perform, it plays into any future RFPs that we have or bids that they have to P&M, because that's going to be something that, is critical to us when we decide on who is a member of our kind of strategic supplier team going forward. Now, obviously, COVID or force majeure type of issues we're flexible on, but things that we believe that are under their control, they need to make sure and live up to that. And if it's a little bit of an expense, that's an issue that they need to make sure and take care of, so that they have a good relationship with P&M going forward. And I think they're understanding that quite well. For instance, GridWorks, when we use GridWorks in our development company, even after COVID, they were 2 or 3 weeks late on getting their project in, and some of the others that went to P&M and Meta were 6 months or a year late, right? Because GridWorks stepped up. So that's why they're something that we look to make sure that they are more of a preferred supplier, because they're able to get things done for the schedule. So that's what we're looking for associated with that.
Okay, thank you. And then I guess just last question, confirming what I'm hearing is PM's going to take a active role in managing these contracts to help make sure they're online.
Yes, me and my team, we will work closely with them to make sure that they do what they need to do. And if they don't, we'll push on the security payments and the damages payments very quickly. So they'll know that's coming.
I appreciate it. And thanks for your testimony here today.
Thank you.
Okay.
Yeah, no further questions. Thanks.
Thank you. Hearing Examiner Ryan, any questions for Mr. Barnard?
Yes, Mr. Barnard, Mr. Dwayne had directed me to make inquiries with you about the monthly demand charge for the Valencia plant. Is that something that I can find in your testimony? Was that supplied, or is there any additional information you can shed light on that?
Yeah, I looked up the revenue requirement that's in Henry Monroy's testimony, a witness Monroy's testimony, and it is approximately $22 million a year. So that's the expected cost associated with that.
So then basically, if the plant is only infrequently used, we can assume the majority of that is the monthly demand charge?
That would be a good assumption. The contract is structured like a lawyer, you're under retainer because it's available, and there's a lot of pass-through costs associated with the contract, and that's been in existence since 2007. And so that's how it's structured. It's available there for capacity. It is when we need it, when P&M needs it, and then there are additional charges whenever it's used. Start charge, any additional maintenance, things like that. Fuel, what we pay the fuel. P&M pays the fuel.
Okay. I don't recall if it was Mr. Dwayne. It was either Mr. Dwayne or Mr. Monroy, but we were also directed to make inquiry with you about the question about the international tariffs we're seeing rolled out at the federal level. And I think part of the concerns that Commissioner O'Connell's asking about staying on top of the developers, I mean, the way we saw the interest rate, the steep interest rate increases play out not necessarily with PNM, but with other investor-owned utilities in New Mexico, was as that environment sort of eroded and money became more expensive, the developers of those facilities basically said, well, we're going to have to renegotiate these contracts because there's no way we can do it at that number. And I suppose the real question that looms is kind of if we end up in a world in which tariffs significantly increase the cost of some of these projects, I mean, how do we have certainty that we'll not just find ourselves having to renegotiate these ESAs or the PPA or whatever? And I think with the PPA, it's probably a bit different because Valencia already exists, but certainly with the ESAs, it seems like that's one concern. And maybe you could tell me if that is a concern.
Yes, I mean, I'm worried about all risk associated with these contracts. Like we're worried about tariffs, we're worried about anything that could happen, war, anything that could happen would impact what could potentially impact negatively these projects. So what we've tried to do is, we have different developers we have two different battery developers that are going to install the batteries at Corazon and San Lasso. We've got our self-build situation, and we're using a local provider for that, a New Mexico company that has a relationship with Tesla for the batteries there. Also, one of the developers is going to use a Tesla battery as well. Can't remember which one now off the top of my head. So we've got domestic supply for those, and then they're also not going to, the other battery manufacturer or the other battery contract with, I think it's Corazon, is, they're looking for other issues to help offset any kind of risk associated with that. But if there's an embargo or anything extreme like that, that would obviously impact the projects that we have going forward.
Okay.
We've tried to handle all that by, as Witness Monroy pointed out, having different choices, different developers, different manufacturers. And I think that the issue here, as PNM grows, it's important and critical to the players. I know we have a very set process, but we want to make it as part of how we review contracts that people that don't produce for us, don't deliver, there's going to be a little bit of an issue for them going forward in the RFPs. And that's important to them. They want to see a relationship with PNM as this state grows and as PNM grows and as renewables grow here. They want to be a part of that. So they have also a long-term incentive to be successful in delivering for New Mexico and PNM.
Well, it sounds like partly what you're saying is, you've learned some valuable lessons with Rockmont, and when an environment changes quickly like it did last time and folks drop out, there's things the company has to do to make sure their partners are going to follow through on what they promised. So it sounds to me like what you're saying is lessons learned.
A lot of lessons learned, and we're trying to get better all the time. Yes.
Great. In your direct testimony at page 3, at lines 10 through 12 there, you're talking about the Valencia plant, and the concluding words in that sentence, the two sentences are: the new agreement replaces that agreement and extends it until December 31st, 2039. And then that last sentence I was puzzled by. PNM has contracted with GridWorks in the past. Was that meant to be Valencia there, or why are you all of a sudden talking about GridWorks in that paragraph?
Yes, hearing examiner, that is another error, Chris. It should say Valencia. It shouldn't say GridWorks.
Okay, I thought as much. That's a simple error. It happens all the time in testimony. It's not a problem. I just wanted to confirm.
Yes.
Can I just ask a real quick follow-up on that?
Sure, go for it.
Good morning, Mr. Barnard. I understand that was a typo there, but has PNM contracted with GridWorks in the past?
Yes. GridWorks built some of our distribution solar sites in 2019, the 40 megawatts associated with that. And GridWorks has done work for PNM, the jointly owned PNM affiliate, Pnm'S owned affiliate with the corporation. They've done work for them as well.
Okay, I'll have more questions about that later. I just wanted to clarify. Thank you, hearing examiner Ryan.
Sure. I'm trying to understand why the dates. So if you go on to page on your direct at page 4, you talk about the terms of the PPA and the ESAs, Can you explain what the driver behind the total number of years contracted? Like how do you settle on those year numbers?
For Valencia?
Yeah. Well,
Yeah.
then even you talk about a 20-year term for the San Lasso and a 20-year term. I mean, those might just be standard contracts for this type of a development for these types of projects. But if you just give me some background on how you settle on those year ranges.
Yeah, and I think Witness Dwayne talked about the Valencia contract. The target for that was for 2040. So they wanted to extend that contract through 2040 based on the modeling that they've done associated with that. So that's why it's kind of a interesting 11.5-year contract. On the ESAs, you're correct. Those are standard time frame contracts that we're seeing. PPAs and ESAs are right now around 20 years.
On page 5, you talk about the nature of the gas turbine in Belen at the Valencia plant. And the question I'd asked Mr. Dwayne was, I understood from the previous case, and I had to go back and check. It's been a while since I've thought about that subject, but I understood Mr. Falgren to testify in that case that really you can't convert Valencia over to run on something that would be considered a renewable fuel. Is that correct, or am I sort of misremembering testimony?
Yeah, I wasn't involved in that case, so I don't know what Mr. Falgren testified to. It would be with current technology, it would be challenging to convert that plant. But I mean, that's 15 years from now in 2040, and who knows what the situation will be at that time, and who knows what the issues around natural gas will be by 2040. So I have no comment on what the future associated with that would be. So that's all.
Okay, thank you. The Sun Lasso and the Corazon both be located in Bernalillo County. Is that why locate them where they are? Just there might be a simple explanation. I'm just curious more than anything.
Yeah, we let the developers, when they do when we do the RFP, the developers decide on the locations where they want to inject power. I think take power and inject power. It's a battery. I think from them, it's usually if they're near a substation, so the interconnection costs are lower. They don't have to do a long gen tie, permitting, having enough land available. And I assume they would do some work with the city and the county and get the feeling that they'd have a positive reception to put those in place. So those are some of the reasons, a developer is going to look for land cost, interconnection, substations. That's the main drivers associated with those.
Those, yeah, go ahead. Continue, please.
Just in my experience, I was just.
Sure. No, that's helpful. It's just background information. I just was curious how they both are in Bernalillo, but it sounds like it's a question largely driven by the developer themselves.
Yeah.
On the next page 6, you talk about the charge discharge cycles for those batteries. I mean, so for how many years can you like anticipate that sort of service?
We expect it for the entire 20 years.
20.
Yes. Yeah.
But I presumably, in like the winter months, I would assume like the battery storage is going to be perhaps. I know there are sort of winter peaks now. We see them with electrification of heating, but like the idea is you wouldn't necessarily be running these batteries every day. It's just that they can be run once a day effectively. Is that the idea?
Right. You get the 365 discharges per year, correct?
Yeah. The capacity charge and the variable operation and maintenance charges, which you describe at page 6 for the Sun Lasso, for the ESAs, basically. Well, in that case, it's just per megawatt hour. Excuse me. Those numbers are for Valencia. Yeah. What is I once had I think it was the 21-215 case too, and I asked Mr. Falgren, like, what is the general going rate for battery storage? I want to say that this was a couple of years now. It was like $6 or something. And obviously that's increased. I mean, so can you just give us a general assessment of like, what are the average prices that you're looking at for these types of battery storage projects, and why should the commission be confident that these numbers are a good deal?
Yeah, I mean, that is a challenging question because of the variability we've seen in lithium pricing associated with the batteries. So, and this is an availability pricing structure. So they have to be available and for us to pay them. As before, most of them were lease structures. I don't know if you're involved with some of the earlier contracts we have are a lease, a monthly KW price. So you can't really compare the megawatt hour price to this, but the range for these, if you compared them to like a lease, are at market or slightly below market currently. What we're seeing, I'm in contract negotiations on some other things right now. They're a little bit higher than these prices. Some of that is tariff fear, tax fears, things like that. But I would say that these are very in market for the time that we sign these contracts.
Okay, and would the Valencia PPA, those terms that we see described there in your testimony at that page 6, lines 13 and 14, which is actually 12 through 14. I mean, is that in the ballpark of the other gas plants? Mr. Rossi referenced several of them earlier when he was talking to Mr. Duane.
The challenge with gas right now, these are very much in range with the pricing that we had in 2007. So when the prices that we had in the 2007, 2008 contract, they increased in inflation every year since then. And then in this contract, we reset them back fairly closely to what they were back in 2007. Now the inflation rates will start up again. But it is kind of so that's a very positive development to move those back. On the gas side in general, all I can say is there's a significant lack of gas resources to build or to buy available right now. I've heard many stories of gas bidders who said, forget it, we're pulling our bids because we sold all of our units to Arizona. I know Arizona just bought 26 LM6000. So I think these are very representative prices, and they're tying to what we got back in 2007 as compared to what the market is now trying to get gas units like that, because they're just not available currently.
And is that because
long lead times for those? I'm sorry, long lead times associated with them.
And is that just because of the nature of like the data center and peaking prices or peaking units being needed? Is that the idea?
Exactly. Yes, you've got a huge growth in data centers, and then you've got a huge growth in renewables, and renewables are intermittent, and so you need something that you can back those things up with.
At page 8, at line 16 there, you talk about, the expected commercial operation date of the ESAs and, what's going to happen, and the way the contracts are structured to make sure that the developers, and I don't want to beat a dead horse here, but when I saw the words you wrote there at line 16, the project will pay PNM liquidated damages on $1 per day for each megawatt of capacity that is delayed. I guess my thought was, well, there's been other cases before the commission where that was supposed to happen, but then it didn't. And it's one thing to say, well, we're going to really, bring the stick down on folks, but then some of the developers will just walk away. So I guess really I guess the point is, this is the best the utility can do to make sure that everything happens in the time frame that it's supposed to.
Yes, I mean, we took several steps, right? We increased the delay damages to make them have a larger incentive to deliver timely. We've gone through and tried to do more understanding who these developers are and feel comfortable with what they can do to deliver. And then I do think that the ability for future opportunity is pretty meaningful to a lot of developers. But you're right. I mean, anybody can wash their hands and walk away, right? To your point, if they feel like something is dramatically changed and they can take a walk. But we try to work with people that we feel that have an incentive, a reputational need to deliver, and then also a future desire to do business with us to deliver, and then also the penalties. So all of that, and that we're going to manage it tightly. We'll be on them. So at least if something comes up, we'll know it sooner. And if we have to find somebody to slide in, we will look for somebody that we can slide in. If anything, it develops on the horizon, and by the fact that you guys, the commission is hopefully approving this early, gives us a little bit more schedule time in there to make sure that we can move quickly to get these into place. So all of those are going on, but the risk you point out is real.
I guess in some level, just hearing you talk and I was thinking to myself is our jurisdiction is limited to the investor-owned utility. That's you all, but in some ways there's a sort of part of this where I guess the question to you is there anything the commission can do to make sure those developers understand if you're going to come in and contract with our regulated utility, we expect you to do what you say you're going to do. I mean, is there anything that the commission can do to aid in that process?
Probably should defer that to Henry and the policy witnesses, but I do think I think we could have some recommendations that would be helpful when we make decisions on who we pick to be the ones that deliver the services or the projects to us. We may want to be able to have some ability to say, hey, this is a reason why we're giving this guy more points or something along those lines that could benefit them as well. But I don't want to, I think that's a policy question for Henry.
Sure. Okay. That's fine. I know it could be just something internally to talk about the commission. I mean, how do we even do that? Because in many ways you could, I understand the utilities position when the interest rates went crazy, it's not as if P&M can wave a magic wand and make people do stuff. If it's just the economics have changed for projects, we saw a whole bunch of stuff fall apart, and that was sort of unsurprising. So then the commission is left with, having to understand what there's a limitation of what the utility can do. So we're all trying to just make sure that at the end of the day, the ratepayers have a reliable service. So anyway, the ramp time on the Valencia plant, I do understand that what Mr. Dwayne said is you can start it quickly, but that incurs a rather significant penalty. That if you were going to start it without that penalty, it is in fact a significant period of time that you need. Am I mistaken on that, or can you speak to that subject at all?
Yeah, there's a start charge for turning on the unit, and then there's ramping, and then they have guarantees around their ability to ramp to full power, and there's penalties if they don't reach ramp at a certain point, if we need it, right? If P&M is saying we need you to ramp to full power by this time frame, and they have to meet certain requirements associated with that. But starting the units, there's an expense, so then there's a cost associated with the start charge.
But then can it be started relatively quickly once you do start it? I mean, it's any start incurs the charge, and then you can ramp it up to full capacity rapidly. Is that okay?
Right. Yes.
That page 10, lines 18 and 19, the project, in addition to the system, you're talking about the Valencia PPA. In addition to the system benefits, the project provides a performance security of $12 million. What is that performance security?
They have to set aside cash to make sure that there's it's like a REIT. They're setting aside dollars that we can draw on if they miss their targets associated with that.
Okay. Good. Then the next line down, the same page of testimony there, page 10, lines 20 through 22, you describe a few things, and oftentimes people say these words as if it's common knowledge, but sometimes it isn't. Ancillary services, you describe frequency response, load following, contingency reserve, and spinning reserve. Can you just give broad explanation of those varying functions?
Yeah, the benefits of the battery is it is almost immediate sub 1 second response to the grid if your communication systems are working properly, right? So you get immediate response. If you have a need, you can call on the battery and get it within a second. So and spinning reserve is meaning you've got available resource, right? So this is an available resource that you can get immediately. Now, the system may not be able to take a 0 to 150 megawatt ramp of the battery, so I don't know how they run it from a grid management perspective, but it's available there, and you can get a battery in a second or two and get that whole 150, like for Sun Lasso, onto the system.
So frequency response though refers, frequency is what, like the amount of like what, I don't even want to use the words amperage or something that the system's operating at, or how is that referring to?
Yeah, I'm not sure which witness I should pass off on exactly how the grid runs, but to your point, it's managing the fluctuations, electronic fluctuations on the system that maintain it, that it works properly. Probably Tom, witness Dwayne would be better at explaining all that kind of stuff.
Okay. Then at page 11, you describe that the Sun Lasso storage is required to post development security equal to 100,000 per megawatt multiplied by the guaranteed capacity, or 15 million. And that guarantee that they're posting, it goes to what the amount that they're actually guaranteed that they're going to be able to generate what they claim they're going to be able to generate.
Well, the 15 million is they post that until they get it online. And then it goes to 18 million, I think.
Okay.
Yeah, it goes to 18.75. So we hold that 15 million in case they're late, right? So
I see.
They're out there for 15 million, and then we post the 18 million to make sure that they hit their availability capability that we've mandated in the contract. So
okay, so here you're basically talking about at lines on page 11, lines 2 through 6. That's the actual construction project, making sure there's a sufficient guarantee that it's going to be built and operating when they say it's going to be.
That's correct.
Okay, and then I suppose that money, if the utility, if that didn't work, like for some reason some delay happens, you guys would use that money to make off-system purchases or however.
Right, that money would go through the fuel clause, I think, to offset the cost that we have to do for off-system purchases. Correct.
Okay.
But I don't know who the financial witness is today. They might be better on how that works.
For the Sunbelt project, going to page 13, the table you have, Pnm table GBB-2. I just noticed the transmission interconnection is relatively low, and I'm guessing that's because you have all that existing infrastructure there.
That's correct.
At page 16, you describe the possibility of, and this is the response to the question beginning at line 16, an additional 20 megawatts of battery storage at the Sunbelt project. What was the thinking out of the gate about having 30 versus 50? Like why even propose it as the possibility of an additional 20?
Excuse me, the request came from Henry, from witness Monroy, about what's the possibility to increase it. I think the target was the 450 megawatts for the school district up there, and we needed additional 20 megawatts to do that. And obviously, battery is something that's very useful to Pnm and to the ratepayers to protect the system. So that's why we pursued an additional 20 megawatts of battery.
Do you know what, is there any way that you can tell me? So at page 22, lines 14 through 16, you write, while the Sunbelt project is not part of the least cost portfolio, the Sunbelt project allows for resources to be located in the CCSD and is the lowest cost resource available there. I mean, what would have been the difference in cost, like, had you not located them there? I'm trying to figure out, like, what's the premium we're going to ask ratepayers to pay to achieve that objective, to build this in the CCSD?
I don't have that information. I don't know if there really was another project similar to this that made the cut associated with that. So I don't have the answer to that. I don't know if Witness, the RFP witness would, because he could say, here's what the other bidders put in and what was the closest. I do think the one thing that I want to be clear on is that that when you're evaluating this, we are paying, P&M is paying gross receipts tax, paying property tax. All of those costs are things that the company is paying to the benefit of the community up there, where if it was a developer who was doing this, they would get an IRB and pay zero gross receipts tax and hardly any property tax to move forward with this.
And the IRB, could you just explain those, the letters, what do they refer to?
Revenue bonds.
Okay.
Yeah. And so what you end up, we've pursued, I know the developers have pursued that so that you usually get a reduction. You know, they're trying to incent people to build in certain locations, right? So if different communities offer to waive all the gross receipts tax and frankly waive property tax or cut it incredibly low, then as a developer, you're going to say that's a good choice, right? Let's go build in that county. And that's attractive, but then it's obviously has an impact on the school system and the revenues of the county and the state if that happens. And
go ahead.
The question came up earlier about comparisons between self-build and developers doing things. And the challenge, the reason that self-builds have been challenging for the utility the last few years is because of the tax code, the IRB. Now they did change it recently. The legislature has changed it that now the utility can get IRBs, but before the utility was unable to. So you were at a competitive, a huge cost differential between a developer and a self-build for certain projects for the utility because of that.
And the I for IRB is industrial revenue bond, is that right?
That's correct. Yes, sorry.
No, that's okay. And okay, so effectively what you're saying is the reason we've seen so many success, or not, I don't know, maybe you're saying this, maybe you're not, I'm asking for confirmation. So much of the development has occurred through the PPAs, through third-party developers, is for the reasons you just described?
One reason with the IRBs, there's a lot of tax issues as well that benefit developers.
And I guess economically, the developers could come in and do stuff if they have processes they've kind of perfected for efficiency purposes, that's something that their business model is sort of predicated on, I guess, right?
I would hope so, but I wouldn't say that. Given
okay.
Some developers, yeah.
Okay. All right. Well, thank you very much, Mr. Barnard. Those are all my questions. Thank you.
Thanks.
Hi, Mr. Barnard. Just a few follow-up questions, I think. I guess the easiest place to start is with the Valencia PPA. I want to ask you first about, Hearing Examiner Ryan was asking you about individual items in your testimony, and I want to direct your attention to page 3, the bottom of page 3. You're asked about the time sensitivities associated with the proposed resources, and I just want to make sure that I'm understanding this right. You have the sentence here about the Valencia PPA where you say the Valencia PPA needs to be approved no later than 360 days after submittal, which assumes no more than 30 days after the November 4th, 2024 signing date. Can you explain that to me? Essentially, is that 360 days from November 4th of 2024?
That's correct.
Okay. All right. That's easy enough. And my next question, again, sticking with the Valencia PPA, I'm hoping you can just put it into perspective for me. On pages 2 and 3, you talk a little bit about sort of the PPA as an overview. I'm assuming, given that there's an existing PPA with Valencia, is it the same nameplate capacity?
They're going to do some enhancements if the contract gets approved to increase the nameplate from 148 to 167.
Okay. And how does the price compare?
So a lot of the individual items or do you mean the price based on the cost that we're paying currently?
Yes.
So we've adjusted some of the prices down back to what the original contract had in 2007. So I'll give you some examples. So, the start charge, the failed start that they pay to us, when the original contract was 10,000, now it's 12,000. So we increased the penalty associated with that. Fixed O&M, the original contract was $2.06. We have it as $0 now. So we've reduced some of those fixed charges to help try to benefit what's going on. The start charge penalty, the start charge that we pay them, $12,494 is what it is currently. It's going back to $8,000, back to what it was in the original contract. And then it'll start increasing again by the inflation factors that we have associated with that. So those are some of the examples. Overall, a lot depends, and I think witness Dwayne discussed this a little bit. It depends on how it's run and how the grid needs are associated with it. If it doesn't get run very much, then obviously the cost would drop to what our current usage of it is. If it gets run a whole bunch, then there'll be additional cost. The expectation that we went in was to keep it very similar to the cost that we had currently.
Okay. Have there been any events of default on the current PPA?
With Valencia?
Yes.
No.
Okay. Next question. I asked you earlier when hearing examiner Ryan was questioning you about that typo on page 3. I asked you just to clarify if you had contracted with GridWorks in the past, and you said that that you had, in fact. So I guess my question is, what has Pnm's experience been with GridWorks in the past? And in particular, have you had any instances of default?
So no instances of default with GridWorks, and GridWorks has been on schedule and on budget for all the projects that we've done with them. We had one project in a Pnm'S, the corporate umbrella. So let me just say that. So with Pnm'S, we had one project that we were building during 2020 during COVID, and they had to shut down the site for a month, and they were 27 days late on that. Obviously, that was force majeure. But compared to everybody else that we had dealt with, they're the only ones that hit their targets. Everybody else was late. And that was an acceptable delay of the 27 days because of the force majeure associated with the COVID shutdown. So we've had really good experience with them, and that is why we have confidence that they'll be able to deliver up there at Sunbelt.
Okay, great. My next question, just looking at page 5 of your direct testimony, you talk a little bit about Sun Lasso and Corazon, these ESAs. And I just wanted to put these in context for my own purposes, and then if there are any questions from the commissioners about it. So both of these are 150 megawatt 4-hour energy storage facilities. Does Pnm have, I'm assuming that you do have current ESAs in place. Can you tell me generally what type of megawatts they are, whether they're 4 or 2-hour storage?
So
put these in context for me.
Yeah, we do have we have existing contracts in place. We have existing resources on currently under ESAs. They're all 4-hour lithium batteries. We have 300 megawatts up at San Juan and Arroyo. I can't tell you the total number off the top of my head. I'm sorry, but it's around 400 or 500 megawatts of 4-hour battery currently that's on the system. And so this would just be in addition to that.
Okay. And can you tell me how the cost of these ESAs compares to the existing ESAs that PNM has?
So the existing pricing is variable because of the timing of when the contracts were signed and what's happened associated with all the contracts that came before. And a lot of them were lease-based contracts where we were just paying a monthly amount, where these are availability based, so they have an incentive to make sure that these are available for us to use. But overall, this contract for these battery pricing with what the current market is, these are very competitive. You got some up and down. Like I said, we're negotiating some other contract. I'm looking at some other contracts currently, and the pricing is higher than this pricing associated with that. You've got inflation, you've got lithium, you've got concerns about a lot of things going on. So there's upward pressure on prices.
Let me ask you about tax credits a little bit. I asked Mr. Monroy about this, and I guess just as sort of the lead in, let me ask you sort of a broad question. On page 6 and a little bit on page 7 of your testimony, you talk about the pricing that PNM will pay under the PPA and the ESAs. If these tax credits at the federal level are either pared back or eliminated, should the commission expect that would have an impact on these contracts in terms of increasing the price?
The developers haven't made any communication about the tax credits, and in the contracts, they're contracted at a fixed price no matter what happens associated with tax policy, right? So that is not a risk that we're willing to take associated with these. But we are aware of what's going on. We hear what's going on potentially around tax situation. So the sooner we get approved a notice to proceed, and historically, these things are always grandfathered in. If you've already got your orders in, if there's any tax change, you're grandfathered in. So we're hopeful the sooner the better, right? Because then no matter what happens, we'll be protected.
Okay. And the answer that you gave here is to PPA, referencing page 6 is to the PPA and the ESAs, but that same logic would apply to the Sunbelt project. That's the reason for sort of a sense of urgency to get that approved and get the work started on that.
Exactly. Yes.
Okay. Now, relatedly, on the subject of tax credits, and I forget exactly where you referenced them in your testimony, but I just wanted to clarify. One of the questions I asked Mr. Monroy was about whether those are, I think I asked him whether they were built into the proposed revenue requirement for the Sunbelt project. Do you know if they are the revenue requirement that he quotes in his testimony? Do you know if these clean energy tax credits are included in that or not?
So I guess that is witness Baker on later today.
No. We have Mr. Jenkins, Mr. Wintermantle, and Mr. Nagel.
Oh.
Or Mr. Monroy. We could recall them, I suppose.
Yeah. Subject to check, I'm confident that they included, I know they included the ITC costs associated, the ITC benefits associated with the battery. And my assumption is they did something similar either with PTC or ITC associated with the solar for Sunbelt. And those were for the battery, the ITC was right at 40% is what they were using.
Okay.
I think that's in the.
Okay. And those assumptions that are used to estimate those tax credit values, are they in testimony? Would they just be in Mr. Monroy's testimony?
They should be in witness Monroy's testimony, correct?
Okay. All right. And I guess would an intervener in this case have been able to find those credits that were used to apply to the revenue requirement?
Find them in his testimony?
Yes. Or just, yes. So let's start with his testimony.
I would think so, yes.
Okay.
I don't know if he put the percentages amounts down. I think they just put the revenue requirements in there in his testimony.
Okay. And then pivoting to a different subject, let me ask you, on the subject of Sun Lasso, and interconnection to substations. If you go to page 10 of your testimony, you talk a little bit about Sun Lasso will interconnect to Pnm's future Sunset Garden substation in Albuquerque. Can you give us just a sense of what the status is on that future substation? Is it under construction right now? Is it planned? Just in case that question does come up from the commissioners.
Yeah, I would defer that to witness Jenkins. But yeah.
Okay. Okay. Fair enough. Let me see. You provided an estimate on page 14 of your testimony for the annual operating and maintenance expense for Sunbelt. And I was just curious. So you talked a little bit about there's an $850,000 figure and then an additional cost for the LTSA for the battery at $290,000. Excuse me. Is that included in the larger $850,000 figure, or is that on top of that?
That's on top of the 850. It's an additional 290.
Okay. And then I think possibly my last question for you, same page. You're asked this question about Pnm's estimate for the annual capital additions for the Sunbelt project, and you talk about future costs needed to offset normal battery cell degradation over time. And I think this gets at a question the hearing examiner Ryan was asking you, but can you give me an idea of what the life expectancy of one of these battery cells would be?
Yeah, I mean, we expect that the battery will last the full 20 years. And you can get warranties for 15, 20 years associated with at least Tesla batteries. But they do degrade over time, kind of like your cell phone battery, right? It's not as good in the 20th year as it is in the first year. And that's why we have this. So what you do is you augment those with additional battery over the life, so you maintain the capability of the system at the 30 or 50 megawatts.
Okay. So I guess overall, is it fair to look at the Sunbelt project as having sort of an overall life expectancy of about 20 years, at least for now?
For now, yes.
Okay. Okay. I'm just checking to make sure I didn't omit any questions.
And just at 50 megawatts, because we'll augment it for the 20 years to keep it to 50. After year 20, you can just let it degrade and you still get use out of it, right? It just wouldn't be at the same level. It would degrade over time.
Okay. And one other question, I guess, about Sunbelt. Are there any local approvals needed to construct that project? And if so, have they been obtained?
So yes, we'd have to get a permit from the county to do that. That's in process associated with that. The county's been very supportive of these type of activities. We are also working on, we've got our Gentai permitted, so that's not a problem there. And then the rest of it is Pnm or Sunbelt land, which is PNMR land. So that's going to be under control it's already under control by the company. So those are the only things that we really need to get completed. And those are all in process, and we'll speed up once we get through the process.
Okay. And so there's no reason to expect that those local approvals would delay that expected completion date of December 31st, 2027?
No, I don't expect that at all.
Okay, great. I don't believe I have any further questions for you, Mr. Barnard. I appreciate your testimony, though. Hearing examiner Ryan, any follow-up?
No, thank you.
Okay. Let's see, Mr. Atencio, any questions on redirect, sir?
Mr. Hearing Examiner, I don't believe I do, though I did have a follow-up question perhaps for you procedurally. You had a question for Mr. Barnard regarding an answer that was perhaps in Mr. Monroy's testimony. And I guess my question is, how would you prefer for us to go about that? We can certainly ask Mr. Monroy, or if it would be helpful, I can point you to the page and line numbers where he discusses that.
I believe I have that. I believe it's on page 23 of his exhibit.
Correct.
4. Is that right?
Yes.
Let me mull that over. If I need any additional information, we can address that after the lunch break.
Then no, I don't have any questions on redirect.
Okay, great. With that, Mr. Barnard, again, thank you very much for your testimony, sir. We appreciate the time.
Thank you.
Thank you. At this point, hearing examiner Ryan, I would be inclined to take a lunch break, unless you have any
Yes.
objection to that.
No objection.
Okay, sounds good. All right, well, we'll go ahead and take, you want to take an hour and come back at 1:15 or just come back
Yeah,
at
1:15 sounds good.
Okay. All right, so with that, we will be on recess until 1:15. Enjoy your lunch and we will be back then. Thank you.
I'm ready when you are, Judge.
Okay, that sounds good. Hearing examiner Ryan, you all set? Okay. Well, we'll go ahead and get started. Looks like we have everybody that we need. Time's now 1:14, and we are back on the record. Let's see where we left off. We had just finished with the testimony from Mr. Barnard. Before we do get started, Mr. Atencio, I had a brief conversation with you before we went on break about some of my questions regarding tax credits. I've gone back, reviewed everything that's been testified. I think I'm satisfied with the answers that I have. So I don't anticipate either a bench request or recalling Mr. Monroy, but I do appreciate your flexibility on that.
Understood.
Okay, so that brings us to your next witness, Mr. Atencio.
Thank you, Mr. Hearing Examiner. PNM calls Stephen Jenkins.
Okay, and I show that he's on. So Mr. Lee, if you'd please swear in the witness.
Mr. Jenkins, if you'd raise your right hand, please. You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, sir.
Go ahead,
Yeah.
Mr. Atencio.
Thank you. Will you please state your name and job title for the record?
Hi, this is Stephen Jenkins. I'm the manager of transmission planning here at PNM.
Do you have before you what's been labeled as PNM Exhibit 7?
Yes, I do.
What is that document?
It's my direct testimony.
Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, it is.
Do you have any additions or corrections to it?
So since filing, we did amend it to add line numbers and page numbers. And also I had a update that on page 5 that the LGIA has been signed for Sun Lasso, and on page 6 that the LGIA has been signed for Corazon since the filing.
Thank you. So just to make sure I understand correctly, you have a correction that that your testimony now includes page numbers and line numbers, and then an update to what has already been filed regarding the status of the LGIA for the facilities mentioned on page 5.
Yeah, that's correct. Page 5 and page 6.
Gotcha. Do you have any other updates or corrections?
No, I don't.
Understanding that since that time there's been an update like you stated, but if I asked you the same questions from your testimony today, would your answers be the same?
Yes.
Mr. Hearing Examiner, I move admission of PNM Exhibit 7 and note that the correct version with the page numbers and line numbers has been uploaded to Dropbox.
Okay, but the answers to questions that he was talking about on pages 5 and 6, there's no revised version to contain those answers. Is that correct?
That is my understanding, yes.
Okay. Well, we can, I think, clarify that through testimony, and that ought to be adequate. There's no objection per the stipulation from any of the signatories. Any objection from a non-signatory as to the admission of PNM Exhibit 7? Seeing none, the exhibit is so admitted.
Thank you, and that's all the questions I have on direct for Mr. Jenkins, and would make him available for any other questions.
Okay. Hearing Examiner Ryan, any questions for Mr. Jenkins?
Yes, just one, maybe some follow-up depending on the answer. The subject amount which you clarified, Mr. Jenkins, the LGIAs, which are the large generator interconnection agreements. As I understand it, part of the national problem with bringing online resources has to do with like interconnection queues, and I don't pretend to have a full grasp of all the details of what that involves, but I just, as I was reviewing your testimony, thought to myself, are these interconnection agreements done the sufficient time that there's not going to be any delay as a consequence of interconnection queues, and just give you an opportunity to explain why I presume the company doesn't think that's going to be a problem.
Yeah, so For the existing facility for Valencia, it wasn't a concern at all. For Sunbelt, the LGIA had been signed back in 2017, so there was no concerns about any risk there. But the two cluster 14 resources, the Sun Lasso and Corazon, at the time of submitting our filing back in November, they did not have signed agreements yet, but we were confident that they were like we had completed all of our study assessments. We had completed the facility study. We were already negotiating the LGIA with the interconnection customers. And we were confident that we would get those agreements completed by the end of last year. So we weren't concerned about that being a risk to this particular resource selection. So.
And when you say that the LGIA for the Sunbelt project was executed in October of 2017, I mean, I'm sure I understand, because like, doesn't that predate the time like you guys were even had abandoned the San Juan generating station, or how does that work exactly?
So the way the interconnection queue works is that developers come to Pnm and propose a project. We do a whole lot of analysis on it, to figure out what the impact is, what the cost of facilities would be at the time of the facility study, and we sign an LGIA, which that holds their position in our queue until such time that they give us notice to proceed, and they go ahead and they find a customer to purchase the power from them, and they begin construction on that facility. So, LGIAs can be around for several years before they begin construction. So, the LGIA for the Sunbelt project happened to be around for several years before it is now being included in this resource portfolio for 2028. And the way to view all of these is that you can go onto Pnm's public Oasis website and view projects that are already in our interconnection queue, and you can find where LGIAs have already been executed for previous projects, as well as view the future projects that are in the queue and the status of the study work that we're working on to evaluate those projects.
Okay, so in other words, when the interconnection queue may reflect the judgment that, in so many years out, we're going to need X amount of capacity here, and therefore, long before any sort of concrete proposal comes up, you have something in the queue that kind of gives you as a placeholder for future concrete projects. Is that what I understood you to say?
So the way that the queue works is that it demonstrates that they already have analyzed the project. We have a good idea of what impacts there will be. We have a good idea of what the costs may be for any interconnection facilities, or network upgrades that may or may not be associated with each of the projects. And so a vast amount of the analysis that my team has done would have already been completed for a project that already has a signed LGIA. And typically for resource planning purposes, they definitely want to prioritize projects that have a signed LGIA over others, because it's a significant risk that if you don't understand what the impacts and costs might be, it's difficult to analyze those in that portion of the analysis in terms of building a portfolio off of it. Whereas if you have a completed study work, you already have a much better idea of what impacts and costs might be associated with that project.
Okay. All right. Well, that's all my questions, Mr. Jenkins. Thank you. Thank you very much, sir.
Thank you, Mr. Exam.
Good afternoon, Mr. Jenkins. Just a couple of follow-up questions so that I too am trying to understand these LGIAs a little bit better. First of all, at a basic level, can you tell me what LGIA stands for?
Yeah, it stands for Large Generator Interconnection Agreement.
Okay. And so it's an agreement between PNM and an interconnection customer?
That's correct.
Okay. Now, do I interpret this correctly that, you know, when you take the Sun Lasso project, this is essentially a separate agreement beyond the actual contract or the ESA that PNM will have with Sun Lasso, but it's a separate agreement with that same entity, right? Sun Lasso Storage. Is that correct? Do you understand my question?
If you're asking if the LGIA is a separate agreement from a PPA or an ESA, that is correct. Yes.
Okay. Okay. And who is the other party to the agreement?
In the LGIA, it would be the developer.
Okay. All right. My next question. So, with respect to Sun Lasso, Mr. Barnard redirected me to you on my question concerning the substation for that project. Mr. Barnard's testimony had stated that the Sun Lasso project would interconnect to the future Sunset Garden substation. Do you know the status of that substation? Is it under construction? Is it ready to go?
So the land is procured by the interconnection customer already. The new substation will be located on their land. So that part's completed. But in terms of breaking ground and starting construction, that can't begin until after notice to proceed is given. And that is contingent upon the approval of this commission.
Okay. All right. And then my last question to you, if you look at page 9 of your testimony, you're asked a question on line 5. Are there other transmission considerations with the BESS facilities? And you said BESS charging from the grid will be possible at all locations, but may be restricted during peak load hours when the highest transmission system loadings occur on portions of the system. Can you explain that to me? I had a hard time following that.
Yeah, absolutely. So the best charging is not part of the system impact study portion. So we only look at the injection side during the analysis. In terms of charging, it's assumed that they will be able to charge during non-peak conditions, which, for example, it may be advantageous to charge with solar during the midday hours and then discharge later at night when the solar is not available anymore. And so there's no guarantee through the LGIA process that they can charge at any time that they desire. But the assumption is that they will charge their BESS when there's capacity available and discharge it when capacity is needed.
Okay, that makes sense. I don't think I have any further questions for you, Mr. Jenkins. I appreciate your testimony. Hearing examiner Ryan, any follow-up?
No.
Okay. Mr. Atencio, any questions on redirect?
No redirect, Mr. Hearing Examiner.
Okay. With that, Mr. Jenkins, thank you very much for your testimony, sir. We appreciate it.
Thank you, everyone.
Let's see, Mr. Atencio, I believe that brings us to Mr. Wintermantle.
Yes, Mr. Hearing Examiner, and excuse me, you bear with us just a minute. We'll get Mr. Wintermantle lined up here and get him going in just a second.
Okay. Okay, looks like we have Mr. Wintermantle. Good afternoon, sir.
Good afternoon, sir.
Mr. Lee, if you'd please swear in the witness.
Mr. Wintermantle, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Go ahead, Mr. Atencio.
Thank you. Will you please state your name and job title for the record?
Yes, my name is Nicholas Wintermantle, and my job title is Chief Services Officer at Power Gym.
I'm sorry, Chief Services Officer at?
Power Gym, POWERGEM.
Thank you, sir.
Sure.
Mr. Wintermantle, do you have before you what's been labeled as P&M Exhibit 8?
I do.
What is this document?
This is my direct testimony for this case.
Was it prepared by you or under your supervision?
Yes.
Is it a true and accurate account to the best of your knowledge?
Yes.
Do you have any additions or corrections to it?
I do not.
And if I asked you the same questions today, would your answers be the same?
They would.
All right, Mr. Hearing Examiner, I move admission of P&M Exhibit 8.
Okay. Again, per the stipulation, there's no objection to this exhibit from any of the signatories. Is there any other objection from a non-signatory as to the admission of P&M Exhibit 8? Seeing none, it's so admitted.
Thank you. And that's all the questions I have for Mr. Wintermantle, and would present him for additional questions.
Okay, thank you. Hearing Examiner Ryan.
It's a Wintermantle. Do you, on your testimony, you answer the question, what is the LOLE, loss of load expectation standard used by P&M? And the company you note, which we've heard from other witnesses, has implemented 0.1 days per year as their LOLE. Is that the thing? Is that the kind of standard that the company just tells you this is what we're shooting for, and we're just telling you that, or do you provide any recommendation as to what the company should or should not shoot for in terms of the LOLE?
Yeah. I mean, P&M ultimately makes a decision on their resource adequacy, but we certainly play a role in that. And the 1 day and 10-year standard is the most common industry standard. If we look around the country, we look at utilities, RTOs around the country, it's been in place for a number of decades. It has served the industry well for determining need of resources and the resource adequacy of a system. So it's a standard that's been in place for some time.
Okay. If and I'm just trying to understand when you with the numbers and Hearing Examiner Camp asked questions about this. So at page 7, you note that P&M's preferred portfolio yielded a 0.064 day per year LOLE. So 0.1 day per year is 1 day every 10 years.
That's correct. Yeah.
So then what's a 0.064? Is that like 1/6 of a day every 10 years?
It would be 0.6 of a day for every 10 years. I can't remember if it was you, Mr. Hearing Examiner, or Mr. Camp. I think they tried to relay it to 6.4 days every 100 years. That would work as well, because equivalent to the 1 day in 10 years would be 10 days in 100 years. So 6.04 days in 100 years would work. And it may provide a little context here. So we're simulating 2028, and we're looking at all different types of scenarios of what could occur in 2028, uncertainty around weather, load, how our units perform, generators perform. So it's a probabilistic look, rerunning 2028 thousands of times. So that's why it's put on this probabilistic number. So that's why you can have a 0.6 days every 10 years. And we're looking for that 0.1 LOLE, which is 1 day every 10 years.
Got you. And then I think that's the thing that struck me with your testimony was the next line there, or the next question. What would the LOLE results show if these resources were not added? And jumps quite a bit, 2.01 days per year. Now, does that mean an LOLE of 2.01 or is it something else that you're trying to represent there?
Yeah, no, so that would mean, yeah, if we do nothing in 2028, the expectation throughout all our simulations, kind of the probabilistic expectation would be that we would have 2 days of load shed. And a day of load shed maybe 2 or 3 hours, 1 hour, 10 hours, but it's just kind of at some point during the day, we weren't able to meet customer load because we didn't have enough resources installed.
And so however specifically like those numbers work out in terms of actual days to days or years to years, whatever that, I guess the jump is that explained because of the batteries coming in to supply demand as the renewables wind down the sort of net peak load? Is that why these resources are having that impact?
That's right. I mean, the assumption is you don't extend Valencia, which is significant generating capacity. The 300 megawatts of storage isn't there, as well as the solar and the Sunbelt project, which is solar and storage. So none of that is there. I think witness Dwayne's testimony talked about a 0.1% reserve margin. So we're basically going into the year barely having enough resources to meet our forecasted load. So basically, if anything goes wrong, if we don't have built something with a 0% margin and we hit our forecast peak load, then we're going to likely have be in a very tight situation and maybe not be able to meet load. And this says that the expectation would be, because we don't have these resources, that we would expect 2 days in that year.
And I guess the question I'm asking is sort of more specific in the sense of, you know, in 21-215, which is the last time that, you know, you and I had an opportunity to talk about procurements and planning, you know, it seemed the message I got from that case was the penetration of solar and Pnm's portfolio is significant enough that they, you know, they're able to generate more than really they need in the middle of the day, and that really the problems all rise towards the afternoon, evening hours, again, when the sun starts to set, and then people are, you know, going home and doing their thing in the evening. And I guess that's the question I'm asking are these battery projects integral in the sense that they're lowering the load loss at that particular time, the summer peak time, evening hours of the highest kind of demand moments in the season?
Yes, you're absolutely correct. The storage resources, the 300 megawatts of storage resources, as well as the Valencia gas resource, are now available during those hours, call them 18 through 22, so 6 p.m. to 10 p.m. when now the need is there. We've got enough solar on the system that from 11 a.m. or 10 a.m. to 4 p.m. we're in pretty good shape. So we're charging those batteries, and now we're using them later in the day. If they were not there, the expectation is that the load shed event is still in that summer evening hours, as you just laid out.
Okay. Figured as much. Just wanted to confirm. Those are all my questions, Mr. Wintermantel. Thank you, sir.
Sure. Thank you.
Good afternoon, Mr. Wintermantel.
Good afternoon, Mr.
I have just a few follow-up questions for you. And I think my main question at this point, so these load shed events, do you know, and you might not, but do you know when the last load shed event for Pnm was?
I do not. Yeah.
Does the company track that, to your knowledge?
I would imagine they would have that somewhere. I do know 2020 across the West, summer of 2020, August across the West, there was a heat wave. There was definitely load shed, I think, in the West. I think it was California. But yeah, I'm not aware of any load shed in Pnm.
Okay. Hearing examiner Ryan was asking you about the 0.1 LOLE and whether that was the standard across the country. Does that play out, I mean, on a practical level for ratepayers if you live in a service area where a utility maintains, let's say, a much higher LOLE? I mean, do they actually end up experiencing that in terms of actually having these load shed events? I mean, it looks like your company is, has probably a broader client base than just PNM. Do you see this play out across the country in terms of these load shed events occurring based on a higher LOLE?
Yeah, I mean, I think the math definitely has proven out that if you maintain lower standards, it's going to be more frequent. But we are targeting this to occur very infrequently. 1 day in 10 years is very infrequent, but over the last 3 or 4 years, there's been significant events across the country. We look at Winter Storm Uri in Texas. That was a resource adequacy event. Now Texas is a completely different market. They are energy only market, so they're not focused on capacity, and or they don't have a capacity market in place. Winter Storm Elliott in the Eastern Interconnect in December of 22 had significant load shed events, but most of those entities were still managing to a 0.1 LOLE. And I think when Roy mentioned it, I mean, we can't ever build the system to perfect reliability. But to the extent those events occur, they are substantial, and is not something that any operator or utility wants to undergo.
And on that point, I mean, one of the conversations that we had, I believe it was probably with Mr. Monroy, was sort of the cost associated with maintaining a lower LOLE, whether we're talking about a 2 day per year or 1 day every 10 years, it does come at a cost. But my understanding is, I mean, obviously one of these actual load shedding events would come at a tremendous cost to ratepayers of the utility. Is that correct?
That is correct. If you look at this, the cost of what occurred in Winter Storm Uri and ERCOT and the prices that went up during that period, yeah, it's substantial. So it's definitely limiting. I mean, it's a risk question, almost an insurance question. And again, the 1 day and 10 year standard has served the industry well, and most entities across the U.S. are utilizing it.
Okay, so let me ask you a little bit about my only other remaining questions for you. I think you talked a little bit with Hearing Examiner Ryan about some of the the models that you had been running in terms of trying to make sure that PNM would have this 0.1 LOLE. And I think you talk about that in your direct testimony. It looks like at page 6, the modeling that you run. Preliminarily, I guess my question is, I mean, are you accounting for, when you run these models and you're planning ahead to 2028, are you accounting for heat increases as well in the summertime? Because that's certainly something that in New Mexico, I think we've seen over recent years that the summers are getting longer and hotter.
We are. So kind of our framework, and I don't recall exactly how detailed we went in my testimony, but we're actually modeling the last 40 years of weather. So the last 5 years of weather included in there. And the reason we do that is because some summers are mild and some are extreme, and we want to kind of understand the full view of what can occur in 2028. So we're looking at, if we have 1980 weather again or 2020 weather again, what the loads look like in PNM. And so you're going to get this broad distribution, and hopefully we're accounting for any kind of possible outcome, and then we're assigning the probability of occurrence to that as well. So the worst summer that we've experienced in the last 40 years, it's getting a 1 in 40 type probability, as it should.
Okay. Now to the specific answer that you give at the bottom of page 6, you're asked about, I think, your assumptions when you're doing this modeling, I think. you give first an answer about how the 2028 RFP portfolios were modeled with certain import constraints. Is the reason why these models were run utilizing import constraints, is it the idea that on these peak days, utilities outside of P&M service area would also be experiencing peak loads, and so their ability to import resources would be limited? Is that the idea?
That is the idea. So similar to what was seen in 2020, think about that heat wave that was across the entire Southwest. I think that event was examined by P&M, kind of discussed with stakeholders as part of the IRP to determine kind of what these import constraints are. We wouldn't want to assume that our neighbors were going to always have capacity for us in emergencies, and us to lower that would allow us to lower our planning reserve margin to something really low. So we want to make reasonable assumptions around what we can get from our neighbors while realizing we are interconnected, and there are benefits to being interconnected Southwest.
Right.
Striking that balance. That's correct.
Okay. And then, I guess my last question for you, just looking at that answer, you talk about they were modeled with a 200 to 300 megawatt import constraint in all hours in which hourly load was greater or equal to 85%. Talk about a different modeling with a 100 to 150 megawatt import constraint. And then I think finally a 50 watt import constraint. Can you tell me why you use those particular constraints? Is that just based on P&M's previous experiences, or your experience with other clients? Just help me understand, I guess, the modeling there.
Yeah, so we actually model the surrounding regions, their loads and resources for 2028 as well. And so when we model the weather years that I discussed earlier, they're getting their weather year too. So we're hopefully syncing up those extreme hot periods. But during times when loads aren't high in the region, we don't put this extra limit on the import constraint because there will likely be available capacity. But during peak periods for P&M, we want to make sure that we have some type of reasonable limit on what can go in. And so the 200 to 300 year round during peak load periods is kind of a base level. And all this has kind of been developed over the last few years, really over time, with stakeholders as part of the IRP. But it is based on kind of historical data. Looking at 2020, it was kind of the last major peak period where I think things were extremely tight, unless something's happened in the last 18 months that I'm not aware of. Because all this was done for the 2023 IRP. But again, so we start with this 200 to 300, and then we kind of ramp it up for that super peak summer period. So you'll see the 100 to 150 and the 50 megawatt limit are only dedicated to summer. And that 19 to 22 hour period that me and Hearing Examiner Ryan were talking about are kind of the extreme periods for the Southwest when the sun's going down. We need that capacity. And so we're limiting our capability to 50 megawatts based on that 2020.
Okay, that's helpful. I don't believe I have any further questions for you. Thank you very much for your testimony.
And I just have a few, Mr. Wintermantel, Commissioner O'Connell had to step away for other appointments, and but he did have questions he presented that he asked us to ask you. So I'm just going to do that here. So I'm not creating more questions of my own. I'm actually just making sure he gets his questions asked, and he couldn't be here to do that. So I'll just read these to you, and then you can, if you have any questions, I'll do my best to answer them. But just answer as you see fit, I suppose. So what is a more reliable metric, LOLE or planning reserve margin?
Yeah, I mean, I think the industry is moving to LOLE. When we think about just the whole process here, we're simulating a system. We target an LOLE, and then out of that analysis, we can go calculate what the planning reserve margin is. So we're adding capacity to the system, adding generation to the system until we get to 0.1. Once we hit 0.1, then we can take the resources that are in the model, peak load in the model, and then calculate a planning reserve margin. But because of the evolution of the system or the transition to more intermittent resources and energy limited resources like storage, it makes the planning reserve margin accounting more difficult. It can be done. We can go calculate. We talk about effective load carrying capability, ELCC. We can calculate that for those resources and get a reasonable planning reserve margin. But what I would say is kind of the gold standard is to actually simulate that portfolio like we've done here and determine, is the system at 0.1? We can, because if we look at witness Dwayne's testimony for 2028, he reports a planning reserve margin for this system. I think it's slightly higher than 16%, which is why we're probably slightly below 0.1 in LOLE. So there's definitely a relationship. But because we're having to, as we add more and more solar storage and wind, the ELCC of those calculations get more and more complex. We still want to always go back and run the portfolio through, just model the resources as they will be with hourly profiles for wind and solar, let the storage charge and discharge like it's capable, and calculate the LOLE and compare that to our target.
And as you're speaking, this is my own sort of insight, and I'll just ask you to comment, if you will. It would seem that to the extent to which what you're describing is calculations predicated upon short duration storage, if we move and technology advances in the long-term storage, would I be right to assume that that's going to have impact, like the introduction of long-term storage, when that is technologically feasible, it will have impacts inherently on the effective load carrying capability and thus the probability of a loss of load event and thus the planning reserve margin?
That's right. So you would start by just, hey, if I've added in 8-hour storage, I'm going to put that in the model and I'll determine what my LOLE is, and that's probably step one. Then separately within this model, we can calculate the ELCC of these resources, and we would probably do the 4-hour and the 8-hour separately. We would determine that the 8-hour ELCC is higher than the 4-hour. The way that we do that in the model, though, is we start at a 0.1 level. So this is a different calculation that I'm getting into, but you get the model to 0.1 LOLE. We add this 8-hour storage resource. That brings LOLE down because I've added generation. And then I'm going to add back load to the model until I get back to 0.1. And so restepping that one more time, I'm going to add in 8-hour storage. My 0.1 LOLE goes down to say 0.05. Now I'm going to add back load. I'm going to get back to 0.1. The ratio of the amount of load that I added, that's the load carrying capability of that 8-hour storage resource. So if I added 1,000 megawatts of 8-hour storage, it only allowed me to move load up 500 megawatts to get back to 0.1. That would give that resource a 50% ELCC. So that's kind of how the ELCC piece is done. But you would do that that's why it gets more and more complicated, because now we're doing that for solar, wind, 4-hour storage, potentially 8-hour storage, et cetera. But still, the gold standard of that is to run that portfolio as it is with the 4 and the 8-hour storage and look and see if when I run that against all my uncertainties for 2028, am I at 0.1 LOLE, or am I above it or lower? Now, if I'm above it, then I'm inadequate. I need more capacity for that summer peak evening period.
Okay. No, I'm gonna have to go read your testimony and just sort of sit and think about that. But it seems on some level, I'm just sort of suggesting intuitively, and maybe I've heard someone say this before, but that the long-term storage will open up. Well, not open up is the wrong word, but like will solve a lot of problems. Put it that way. I mean, it's a really necessary part of the system at this juncture that we don't have. Is that just generally kind of correct?
Yes, you're going to need dispatchable resources. So whether that's long-term storage or gas that's dispatchable or some other type of resource that you can call on like we've talked about in that hour, 16 to 22 when you need it most. And as we add more and more short duration storage, it pushes us to really extend that length longer, and we're eventually we'll need longer duration storage or a fully dispatchable resource like a gas unit.
Right, but if you're in a carbon-free environment, the gas units themselves have to be capable of running on something that's a zero carbon resource, which I understand at present purposes, like we don't have that either technologically.
Correct.
So this is good. It's always interesting conversation. Next question from Commissioner O'Connell. Are there any other metrics that the commission should consider as evidence that there is a reasonable expectation of affordable, reliable service? And if you want me to read that again, I can.
And maybe one more time, please.
Sure. So are there any other metrics that the commission should consider as evidence that there is a reasonable expectation of affordable, reliable service? And I guess he's asking, so beyond maybe LOLE or planning reserve margin, because we've identified those, maybe is there anything else that you, as a planner, think about, or that the commission should think about to have certainty that we have reliable and affordable service?
Yeah, I mean, nothing urgent comes to mind. I do think across the industry, there's thoughts around expected unserved energy. And what that is the megawatt hours of energy that we weren't able to shed. So an event it's exactly that. It's counting a 1 every time we have firm load shed. But I think there could be concern that if we're adding limited storage, and I'm talking beyond 2030, 2035, we get to this system where we're completely carbon free and we've added lots of short-term or short duration storage. There is potential that our expected unserved energy, even if I'm at 0.1 LOLE, my expected unserved energy could actually creep up. So my events could be a little larger in magnitude than they are now, but I could still be at a 0.1 LOLE. So there's been discussion in the industry, I think, forward looking, should we be looking at kind of the magnitude of these events more, or at least keep an eye on.
Okay. And then what does expected unserved energy tell us in addition to LOLE or planning reserve margin? Expected unserved energy.
Yeah, kind of answered my previous. Yeah, so expected unserved energy is during a load shed event, so hours 19 through 22, it's determining the megawatt hours that we could not serve. So it's the unserved energy. So again, it's a megawatt hour magnitude value versus LOLE is the number of events. So again, it's events versus magnitude. And so I think, as I said earlier, forward looking out beyond 2030, 2035, there is some discussion around whether we should be looking at expected unserved energy to Mr. Chairman O'Connell's question there.
Okay, well, those were all his questions that he asked us to inquire about. I have nothing else. Hearing Examiner Krankamp, if you have follow-up, something.
Okay. I don't have any follow-up. Mr. Atencio, any questions on redirect?
No questions, Mr. Hearing Examiner.
Okay. With that, Mr. Wintermantle, thank you very much for your testimony. We appreciate it.
Thank you.
I believe that takes us back to you, Mr. Atencio, for your 6th and final witness.
Thank you, Mr. Hearing Examiner. PNM calls Mr. Roger Nagel, and we'll give him, if he could just give us a second, we'll get him hooked up here, but he should be ready and waiting.
Okay. Okay, looks like we have Mr. Nagel with us. Good afternoon, Mr. Nagel.
Good afternoon.
And Mr. Lee, if you'd please swear in the witness.
Mr. Nagel, would you please raise your right hand? You solemnly swear that the testimony you're about to give the matter now pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Go ahead, Mr. Atencio.
Thank you. Will you please state your name and job title for the record?
Yes, my name is Roger Nagel, and I'm a principal with Ion Energy.
Do you have before you what's been labeled as P&M Exhibits 9 and 10?
Yes, I do.
What are these documents?
Exhibit 9 is my direct testimony in this case, and Exhibit 10 is my supplemental testimony.
Were these prepared by you or under your supervision?
Yes, they were.
Are they true and accurate accounts to the best of your knowledge?
Yes, they are.
Do you have any additions or corrections?
No.
If I asked you the same questions today, would your answers be the same?
Yes, they would.
Mr. Hearing Examiner, I move admission of P&M Exhibits 9 and 10.
Okay, thank you. Again, per the stipulation, there's no objection to the admission of this exhibit from any of the signatories. Any objection from a non-signatory is the admission of P&M Exhibits 9 and 10. Seeing none, P&M Exhibits 9 and 10 are both admitted into the record.
Thank you. And that's all the questions I have for Mr. Nagel, and would present him for any other questions.
Thank you. Hearing Examiner Ryan, any questions for Mr. Nagel?
Yeah, just a couple here. Just for clarification, Mr. Nagel, the page 5 of your direct testimony, that P&M table RWN-1, just want to make sure that I'm understanding these abbreviations correctly. ESS on the second row, that's energy storage system.
That's correct.
Gas aeroderivative.
Correct.
And that's distinguished from gas frame. What is the frame?
Yeah, so aeroderivative is more of a airplane engine, for example, whereas a frame gas turbine is a ground-mounted heavy-duty frame combustion turbine is what they call them. So they're typically larger in size than the aeroderivatives are.
Okay, great. Then moving across the columns there, EPC, I know I saw this someplace in your testimony. Could you just remind me what that one was?
Yeah, that would be engineer, procure, construct.
Right. And that's different than the utility self-build from, would the utility self-build category be specifically like truly P&M using its own resources to build the thing? Or no?
Right, utility self-build would be, P&M is selecting the contractors and building the project on their own behalf.
Okay.
Whereas, EPC would be a separate contractor building it for P&M, under contract as well, but not.
Okay, so in this case, the grid works with this as a utility self-build.
Yes, for Sunbelt, correct. That
Correct.
is the utility self-build.
Okay, good. When this question came to me as I was reading your testimony there on page 5 at lines 12 through 15 below that table. When we introduce something really specific like the resource has to be constructed in a particular geographic location for the complex reasons that this had to be built in the CCSD. How do you go about in an RFP process of ensuring like that specific unique criteria still ensures an objectively fair process for all bidders?
Yeah, so we executed the RFP evaluation the same regardless. And what we did was, to the point of the process, we ensured that there were projects within the Navajo Nation and within the CCSD that were shortlisted so that they could be evaluated in phase 3 of the evaluation process, which Witness Dwayne talked about earlier. So if we get through the evaluation and we may or may not have projects in the Navajo Nation or CCSD, we will add those into the shortlist to ensure that they are accounted for and evaluated as an option. So we're not favoring them, we're not selecting them over others. We are just adding them, making sure that we have those as part of the ultimate, more detailed evaluation in phase 3 of the process.
And I guess as the bids come in, for something like that, I mean, I suppose a starting place. I mean, I'm posing this more as a question than a statement. I mean, did you get in this case, for instance, multiple builds to build in the CCSD, and then so many of them advanced? And I'm sorry if this is in your testimony, I just can't recall. It's a lot of information for one day, but so many advanced to this next phase because they're the most cost competitive, and then from there you're selecting, or how do you ensure that there's bids to begin with and then a selection process that filters you down into one that you select?
Right. So I'll try to hit the numbers. They may be off a bit, but in terms of, for example, the CCSD projects, I believe we had around 21 projects entering into the phase 2 bid evaluation, and we carried 6 projects into the final shortlist after phase 2. Similarly, in the Navajo Nation, I think we had 9, and we narrowed it down to 3 on the short list. So, the short list is a best-in-class type selection. So we look at technologies, and we select the proposals that offer the most favorable characteristics by technologies. And so, yeah, again, most of these projects were carried into the short list regardless of whether they were in the Navajo Nation or CCSD. But we just wanted to make sure that, there were sufficient bids there that we could evaluate against all the other bids received under the RFP.
And then, earlier we heard explanation, which is completely sensible to me. One of the ways that PNM is mitigating developer or contractor, abandonment if economic circumstances go south, is by working with known contractors, right? Who have proven track records of completing projects in timely fashion. And GridWorks, we heard earlier, is one of those. So how does that get baked into the sort of, and as an objective metric into the RFP process, that GridWorks has done stuff before and they have a proven track record. So therefore, I guess therefore they're given so many more points, or we just consider that as an additional indicia of they should get the bid, or how does that work?
Yeah, so Exhibit 5 of my testimony goes through the bid evaluation methodology that we use, and there is a matrix that weights both price factors and non-price factors. And within those non-price factors are, the bidder's experience, their history of performance, their commercial terms. There's a number of factors in there that are considered, their safety record. And it's through that ranking of these various categories in that ranking matrix that those types of things are evaluated and considered. So that ultimately there's a weighted ranking of each proposal, considering all these factors that help select the shortlist.
Would it be the case to say that if like in the Rockmont project, and I don't know enough, I don't know who the developer was, and it's not really important who that was, but would it be the case that if a developer fails to complete, or just doesn't come through for whatever reason, it could not even, that they would not then have opportunity in the future? I mean, would they just be sort of categorically precluded from even getting into the fray?
The more recent RFPs do preclude developers that have defaulted for PNM. The others, we just look at, if they don't have as much experience, they're going to rank lower in the experience and capabilities category. If that makes sense.
Yeah. part of the challenge for the utility, and I'm aware of this not only with PNM, but other New Mexico utilities. I had a El Paso Electric case where this was an issue. You know, the economics of a particular proposal, I think in that instance, it was like one of the least costly solar installations in the state's history. It might have even been like in the United States. So it was very low price. And I think that reflected very low interest rates. And then all of a sudden we're calling like recent history, interest rates just went through the roof. We had record inflation. And then that project fell apart. That at page 9, you talk about the RFPs and the extent to which you can ensure that they will deliver on a timely fashion. But it seems to me on some level, are there things that you just all of this can only take you so far, but if things change dramatically, there's really no way to ensure that the developer is going to come through if the ground situation was to change significantly enough. Is that a true statement?
I would say that's true. You know, and to kind of the discussion earlier today on lessons learned, I think, you know, we've learned on some of these topics and, you know, weighting things a little bit differently now where, you know, when you see a really low price, that isn't always necessarily the best thing, right? You know, you need to account for their capabilities, the status of development of the project. You know, are they far enough along on transmission interconnection, other things to really deliver on the project, you know, per the RFP requirements. And that's really, you know, come more into play in our evaluations in these later RFPs.
It does seem at page 10, you write, this is at lines 14 through 20. Additional information was requested of the bidders regarding any prior contractual defaults. And you said, with the exception of one bidder who had recently defaulted, this information only did not serve as a differentiating factor. So it does look like we had bidders here who previously defaulted. They were bidding.
Yes, that's correct.
Okay. So, and were any of those folks categorically rejected as you know, even like right out of the gate, for lack of a better term?
I don't believe we rejected that one right out of the gate. I believe, you know, it was in phase 2 that we, you know, looked at that again and reevaluated and, you know, decided, yeah, we don't want to go there again.
At page 13, at lines 19 through 20, you write that the RFP was structured with no resource type or project ownership structure specifically requested, preferred, or excluded. And I was wondering why you would do that given the renewable portfolio standard increases that we're anticipating. I mean, aren't the resource type should have, I mean, it would seem to me has to be, in order to comply with the REA, be renewable energy, right? Or I mean, I suppose battery storage that's kind of a weird hybrid thing. What is battery storage? But that was my question that I was wondering, and I saw that statement there. I was like, seems like it should be a renewable resource.
Well, you know, as you know, historically we tried to frame these as all source RFPs. So we're leaving it up to the bidders to determine what they want to propose to PNM, you know, with the understanding that they have access to the IRPs. They know PNM's goals and objectives, you know, through the documentation of the IRPs, and leaving it up to them to offer, you know, the types of resources that they feel, you know, might be suitable or favorable to PNM. You know, I guess part of that is, you know, we don't necessarily want to restrict, you know, if someone does have a gas-fired unit that can burn 100% hydrogen, you know, that leaves that open for them to bid that type of resource into the RFP. So we try not to be restrictive, but obviously at the end of the day, we're still trying to target the goals and objectives of, you know, carbon free by 2040 and
Is it realistic to think that the RFP is the space where, say, someone did come up with the technology that I understand doesn't exist at present, a New Mexico gas company obviously would be very interested in this. If you could find a fully clean burning gas resource, it would seem to me that innovation would be significant enough that, like, in reality, you probably wouldn't learn of that or proceed to obtain that through RFPs. It would be some other. I'm really just making that up. Would that be accurate or no? You would really literally hear about it for the first time in an RFP or response to an RFP.
You would have most likely heard about it prior to an RFP, but I've been shocked before with new technologies proposed. The next question then is, it's a new technology, how much do we trust it? And how would we select it under an RFP or not? So there would have to be a lot of investigation at that point. But to your point, you would typically be aware of the technology before you see it in an RFP.
Okay. At page 19, you respond to the question as part of the RFP responses. Did PNM receive any long duration storage bids? And the answer is no. None were received with. My question was basically, why is this in your opinion? And my guess is you'll tell me something about technology. But if maybe you've been involved with enough of these things, perhaps there is some tech out there, and maybe it's just not being bid into PNM's service territory. But you maybe can clarify that for me.
Yeah, I mean, there was a bit of a discussion earlier that it is, concern with, technology development. There are these long duration storage technologies becoming more available. They obviously don't have the amount of experience that the 2 to 4 hour lithium ion, batteries do have at this point, but pumped hydro, is a well-known long duration storage technology. So that's out there, various battery technologies as well. But, we're encouraging those longer duration storages offers in current RFPs, and, we'll certainly evaluate and consider those going forward.
Scanning your testimony. I'm not sure how many more questions I have here. Okay. Right at page 30, lines 12 through 16, in support of the desired May 1, 2028 guaranteed start date, it is noted 2 of the projects selected by the RFP administration team have interconnection agreements in place, with the remaining 2 having entered the interconnection queue in 2021. I'd ask Mr. Jenkins, just you read about this interconnection queue stuff all the time in this field, and I don't necessarily have to have some like deeply granular understanding, but it was surprising me to learn that, outside of these requests for proposals, these interconnection agreements are formulated. And maybe can you perhaps clarify further, like just take another swipe at explaining that process? Because that's the first not the first, but it's not a subject that I've had enough exposure to, I think, I'd like to say.
Sure. Yeah, I'll try number 2. I think as far as, so developers are always looking for the next place to build a new project, right? And so they're looking at, where they're seeing load growth, where they're seeing opportunity to build a project that they can sell into the market, or to, off takers, such as a large data center customer or something like that. So developers are, being proactive at times, selecting locations where they try to get an interconnection agreement in place, so that, they may not use it today, but they might use it 5 years down the road when a predicted, large consumer is going to be constructed in that area. Utilities can do the same thing. They can, get interconnect agreements in place proactively, understanding their load growth and, their objectives for new resources as well. So it's not that an interconnection application can only be associated with a project that's being bid at the time. It can be proactive and be several years ahead of time, in the hopes that, that developer or utility will build a project at that location. Does that help?
It does. It makes me wonder, like, I don't know if this is the case or not, but it seems almost like you could have like an interconnection agreement marketplace where you could sell these things to people. Does that exist?
Not necessarily. I mean, there are times when developers will sell their interconnection agreement to another developer when they're not seeing their opportunity move forward, but another developer is, making progress with the utility or someone else and they need, that interconnection. So there is a bit of that occurs where the selling of those interconnect applications occurs, but I don't know that there's a market, an established market for that.
Probably because because it sounds like from what Mr. Jenkins told us that achieving the interconnection agreement is a relatively robust process in and of itself.
Right.
You wouldn't undertake that frivolously. It would be very okay.
Right.
We've had a lot of discussions about the potentiality for some of the tax credits and other federal incentives going away. We've heard answers from varying witnesses. I guess I'll just give you an opportunity. Do you have anything to contribute further to that about what, whether we should take that into consideration and what do we do about that? I mean, obviously no one controls that.
Right.
So.
Yeah, I don't know that I have much more to add beyond what's already been discussed. I know, that this applies to, the PPAs, the ESAs, and the self-build projects equally. So, as witness Barnard mentioned, as a utility self-build, have a little bit more control over it under that situation, but it is a common effect across the board.
Right. That's all the questions I have for Mr. Nagel. Thank you, sir.
Thank you.
Good afternoon, Mr. Nagel.
Good afternoon.
Just a couple of questions for you. My first question, my biggest question, if you look at page 46 and 47 of your testimony this is your direct testimony, so exhibit 9.
Okay.
I want to ask you about the findings of the independent evaluator about the RFP evaluation process. So I've read through this answer. The independent evaluator ultimately finds that Pnm's results were reasonable. They agreed with Pnm's selection of the least cost portfolio, finding that they represent the least cost resources to meet the RFP targets and achieve Pnm's 0.1 LOLE. And then I reach this last sort of paragraph of that answer. And you say the independent evaluator also stated with respect to the inclusion of a project within the CCSD that, quote, assuming that such a project is required, Pnm's selection of the Sunbelt project was appropriate. And so I guess my question is, when I read that, am I to interpret the independent evaluator's comments about agreement with the selection of the portfolio and all that as contingent on acceptance of this assumption that Pnm is required to put the project within CCSD? Do I read that correctly?
Yeah, I think we kind of talked through it earlier today in that least cost portfolio that resulted from the RFP, did not include the CCSD project. So the question was, with with the desire to include a CCSD project, that this would be the project to include as a result of the RFP evaluation. So that I think that's what they were trying to say is it's not necessarily the least cost portfolio, but it is the least cost portfolio with the CCSD resource.
Okay. Now, did the independent evaluator, I'm assuming that the question of whether the project was required within CCSD is beyond the evaluation process. Is that correct?
It is, yes.
Okay, so that's not something that they would have looked at, and that
Right.
makes sense. Is there an indication from the report as far as what the cost difference was? That was a question that we had asked, I think, Mr. Monroy, and I think if I'm not mistaken, he may have suggested that we ask that question to you.
Yeah, I think witness Dwayne would be the best for that because they did the detailed phase 3 evaluation looking at how the resource fit into the portfolio and how it would operate and the net present value benefit of that resource in the system. So I guess unfortunately I would defer to him to really answer that because they looked at a lot of different sensitivities and approaches to the selection process.
Okay. And then just last couple questions. This is about Exhibit 10. Or not, yes, Pnm Exhibit 10. And I think the primary purpose of this particular exhibit was to make sure that there was a copy of the independent evaluator final report.
Correct. That was the sole purpose of that.
Yeah.
So,
And I think my main question here, did the parties in this case, so staff and then the interveners, did they have an opportunity to review the unredacted copy of this final report? To your knowledge?
I don't know the answer to that.
Okay. Okay. I don't think I have any further questions for you. Thank you, Mr. Nagel. I appreciate it.
Thank you.
Let's see, Mr. Atencio, any questions on redirect?
I don't have any questions on redirect. Mr. Hearing Examiner, regarding your last question, I would point to the confidentiality order and the process that was associated with that regarding the availability of unredacted versions of the evidence provided by Pnm.
Okay, thank you. Hearing Examiner Ryan, anything further?
No.
Okay. Thank you, Mr. Nagel. We appreciate your testimony today, sir.
Okay, thank you.
Hearing Examiner Ryan, do you want to take a morning or afternoon recess before we take staff's witness?
Mr. Lee, what's your preference?
I would prefer a break.
Okay.
There you go.
Let's do that. We'll go ahead and come back at, let's say, 2:40. And for now, we'll be off the record.
I'm ready when you are, Judge.
Okay, we're a little early. We gave the parties until like 2:40, so when they're all here, then we'll get going. Okay, we're a bit early, but it looks like we have everyone here. Mr. Lee, you ready, sir?
Yes, sir.
Thank you very much. Okay, we'll go ahead and go back on the record. Time is 2:37. And where we left off, I believe that PNM had just finished with its final witness. Is that correct, Mr. Atencio?
Yes, that's correct.
Excellent, thank you. So that brings us to you, Mr. Rossi. Please go ahead and call your first and I believe only witness.
That's correct. Thank you, Mr. Hearing Examiner. Staff will call Darren Zigich.
Okay. Mr. Lee, if you'd please swear in the witness.
Mr. Zigich, if you'd please raise your right hand, you solemnly swear the testimony you're about to give in the matter now pending to be the truth, the whole truth, and nothing but the truth.
Yes, I do.
Thank you, sir.
Go ahead, Mr. Rossi.
Thank you. Good afternoon, sir. Would you please state your name for the record?
Darren Zigich.
And how are you employed?
I'm an engineer with the New Mexico Public Regulation Commission, Utility Division staff.
As part of your job duties, did you review this application?
Yes, I did.
And did you prepare testimony for this proceeding?
Yes, to the stipulated settlement.
Is this, or do you have a copy of exhibit staff exhibit number 1?
Yes, I do.
Is this exhibit your sworn testimony in this matter?
Yes, it is.
And was this testimony prepared by you?
Yes, it was.
If I asked you the same questions today, would your answers be the same?
Yes.
Are your answers true and accurate to the best of your knowledge?
Yes.
At this time, staff moves to admit staff exhibit number 1, the direct testimony of Darren Zigich.
Thank you, Mr. Rossi. Per the stipulation, there's no objection to the admission of staff's exhibit 1 from any of the signatories. Is there any objection to the admission of staff's exhibit 1 from any of the non-signatories and the other parties to this case? Seeing none, it is so admitted.
I have no further questions for this witness. I pass the witness.
Okay, thank you very much. Hearing Examiner Ryan, do you have any questions for Mr. Zigich?
Yeah, just a couple. Mr. Zigich, do we know, and I think well, I'm not trying to ask a trick question. Like, I guess as I was thinking about this case, the first thought that came to my mind was, what does this mean for the average ratepayer? And, you know, I understand from a loss of load expectation, why this is necessary. And then my discussion with Mr. Wintermantel, it's pretty much exactly what one expects. You know, you need to have the battery storage in order to shift generation or shift power from the sort of early evening to the later evening, right? Like that's the big problem that we confront as a grid. So, but then that doesn't answer the question, like from an engineering perspective, like I can understand exactly why this has to happen. But then the question becomes, well, what does the ratepayer pay for this? And it sounds like at this juncture, until Mr. Monroy provides that additional response, we don't know the answer to that question. Is that correct?
Yeah, well, partially. I mean, he has, Mr. Monroy in his direct testimony did, you know, on page 3 in his table, HEM 1, he does give the revenue requirements. And of course, we have to remember that the PPA for Valencia is very similar to what it is now, so that's not really an adder. So there's still a $50+ million increase, and as you know, both hearing examiner Ryan and Camp, we just got done with $105 million increase, so we're already halfway there just on this set of resources. So you know, I think that kind of gives a good window of what's to come.
Yeah, and I mean, I think from my perspective, the commission always has to be concerned with affordability. And the other question I have is, you know, when we talk about this particular case, and obviously the rate making treatment for these won't occur until some subsequent case, but the approval now effectively sets into motion the process by which these dollars are added to the revenue requirement. You're not going to take those away. The staff have any concern in this case that, you know, we're just piling on cost to the ratepayer. And I don't know when the ratepayer breaks, but is it that going to happen at some point?
Yeah, I mean, this also came up in the last resource case, the 23-353 case. You know, so we've been watching this for a while because batteries, frankly, are not cheap, but we've gone down this road, and with all the generation resources, the variable generation resources you need at times of the day or times of the year, you need places for that energy to go. Right. Otherwise, it's just going into the ether and it's being wasted. You know, we do have some curtailment numbers from Pnm through discovery, and it's already fairly large. You know, tens of millions of dollars worth of power is being basically shut off, curtailed, because there's not enough storage. So you've got that balance of if you keep buying too much, that's costly, but if you don't have enough, you're wasting power because of the way these resources work. They're not always contemporaneous with the load. And so you need something. But yeah, I think staff has been pushing for longer duration or longer term resources, you know, like pumped hydro, not just because it's a long duration storage option, but unlike a battery that may have a 20 or 30-year lifespan, a pumped hydro facility can last 80 years. So that capitalization, you know, that depreciation of it goes out over many, many decades.
Sorry, what type of facility did you say there? I didn't know if I heard you correctly.
Like a pumped hydro.
Pumped hydro. Okay. Yeah. Okay.
You know, something that's an available technology. The difficulty of that is the time horizon. You need many years to permit it, to site it, to build it. But you know, just an example. I mean, there was a project, and I don't want to compare Chinese costs to American costs by any means, but you know, the Chinese just finished in August the largest pumped hydro facility, you know, that finally took over the Virginia facility in size and capacity last year. And that, for instance, you know, they paid reportedly $2.6 billion for that project, and it's 40 gigawatt hours of capacity, of energy capacity. Pnm, if you piece together all these ESAs, you know, the capital expenditure that Pnm has put in is right in that ballpark of total expenditures. Now, some of it is contract, so it's not all capital that's going in on the Pnm books, but still, it's over $2 billion worth of equipment for roughly 4 gigawatt hours, so 10 times less. And so that's the other reason for looking at these longer term solutions. Hopefully, from an energy storage standpoint, they'll be cheaper. And they'll have a longer lifespan potentially than your typical battery system so that you can spread those costs over multiple generations.
I think the point you made earlier about curtailment and then the extent to which that is a consideration the commission has to take into mind when thinking about the necessity for battery storage in these expenditures. If in fact that curtailment can be lessened through these. I mean, has staff done that analysis to kind of show like, hey, look, if you build these batteries, here's how much curtailments we're going to be able to avoid?
Well, I mean, we have in some of these discussions, you know, that the additional capacity that, you know, the extra 20 megawatts, for instance, up at the Sunbelt project, that would help curtailment by 6,000 megawatt hours a year. There, you know, rough numbers that PNM has offered us. So that kind of, you know, if you can get 6,000 megawatts for 20 megawatts of storage, of 4-hour storage, you know, it kind of gives you a ballpark of, you know, you can scale it from there as to what can be done. But, you know, we got some numbers of their current renewable curtailment, and some of it is due to transmission constraints. Some of it is just due to, you know, the wind is blowing and the sun is out in April and there's nowhere to sell it because the EIM price is negative. So there's no point in selling it there. So you might as well shut it down. You know, so there's multiple different reasons, but if you just take the total megawatt hours that they're curtailing over a year and compare it to like the average EIM price over 2024, you're looking at, you know, $30 to $40 million of curtailment. And, you know, that buys a sizable battery. You know, if you can, you know, take care of some of that curtailment or have some other resource that can absorb that and defer it to a later time. So the energy arbitrage question gets to be more important as we move along in this energy transition. And the thing with PNM, I think, is the first utility to really get to this stage, probably nationwide, because not only do they have the RPS requirements, they also have that carbon limit. And like I was saying in my testimony, that 400-pound limit is very restrictive. I don't think we had a good appreciation for how restrictive that is, but it's highly restrictive, especially when they still have Four Corners chugging away at, you know, on their system. That doesn't give them much room to run their gas facilities. They really limit the usage of that so they can stay in compliance with the pounds of CO2 per megawatt hour limit. So storage and renewable generation become very important in that mix.
Okay. That was really the only subject I wanted to address, which was, you know, how did staff come to its conclusion that, you know, the ratepayers can be asked and, you know, told, hey, look, we know you don't want to have to expend more money, but this is really essential. And then gauge that against how much expenditure is being you know, set into motion here, and then what does that collectively mean for the ratepayer in light of all of the varying cost increases that the PNM is putting into motion? Because it's not just this rate case, or not this procurement case, it's the rate case, it's the riders, it's lots of stuff. So
yeah, and I think, you know, PNM is rightfully pushing the envelope out on their next RFP to hopefully get more options. As you increase your timeline, there may be more options out there available for selection. Right now, it's kind of trying to make sure they can keep the lights on, and so it's take what's available and move on. And that's that's what we're kind of in that cycle right now. But I think a lot of utilities are in that cycle. They're trying to catch up with the load increases.
Okay, thank you. That's all I have for Mr. Zigich.
Thank you. Hearing examiner Ryan. Good afternoon, Mr. Zigich.
Hi, hearing examiner Krenkamp.
Before I ask my questions, I just have a few. I just want to go back at the beginning of the hearing. I believe when Mr. Monroy was testifying, we talked about a potential bench request issued to staff, as well as the NMDOJ and PNM around a couple of questions that hearing examiner Ryan and the chair had. And I think the first question of those, which related to affordability and the impact on customer costs, I think you've spoken to that already. But let me ask you the other two questions. And if you don't have an answer, that's okay. I mean, we can do the bench request. I just wanted to give you an opportunity to answer them live if you're able to.
Okay.
The second question was, what does staff see as the primary use for battery? I think this was battery storage. Is it battery storage? Is it energy arbitrage? Is it something else? What are the important secondary uses for batteries?
Well, the nice thing with the batteries is that they basically provide all of those benefits, from transmission and system stability benefits to energy arbitrage, which limits curtailment. So you're limiting the waste of generation. Because we got to remember, a lot of these solar and wind projects are PPAs, so we're paying for the energy if it gets delivered or not. A lot of those PPA contracts are take it or leave it type of contracts. So if the system can't take it, then we're just paying for energy unused. And so that's never a good thing. So the arbitrage, the problem with the 4-hour battery is it's very limited on its energy arbitrage. But we did ask PNM for their economic dispatch for 2028. And it's quite remarkable, really, when you look at it. I mean, with Palo Verde, they're almost at 80% zero carbon by 2028, which is way ahead of where they need to be, where they would need to be under the RPS, the REA, but they need to be there because of this 400-pound carbon limit in the ETA. And it's quite impressive that they can actually get there, but that takes a lot of generation and a lot of storage to do that. And there's times in 2028, basically from April to June, the gas facilities essentially shut down. There's just not much on the system. They purchase a little bit from the market, but it's really quite staggering to see what's coming. From an engineering standpoint, it's just really interesting to see that dynamic and how that whole system has changed over the years, and to see that they can actually do it. That's quite remarkable. So in that sense, it's nice to see. But yeah, batteries are not the final solution by any means, and so I think we're getting to the point where they're having limited use moving forward. And I think Mr. Wintermantle talks about that, that we need to move to longer duration. Otherwise, you just start stacking 4-hour batteries to get through the night. And that's a heck of a way to do it. Because then you're just adding capacity that you don't really need. You need the battery more for the energy than you need it for the capacity. But right now with load growth, they basically need both. And so it's still in sync, but eventually it's going to get out of sync. And that's where the longer duration storage or some hydrogen resource, something else is going to have to come into play.
Thank you. And then the third and final question, and I can repeat this if you need. With respect to the various pricing that's available on batteries, we have utility owned and dollar per megawatt hour. How do those mechanisms support optimizing the primary use, or do they provide a perverse incentive to somehow not use these batteries in a way that is best for customers?
Yeah, that actually, some of those questions did come up in the 353 case that, we were asking. I don't, like again, we asked P&M for their economic dispatch model. And I think once you have a battery in place, you're going to use it. If it's charged, they're going to use it. It's the cheapest thing. They're not going to call up Valencia for $8,000 a start and the gas price and everything else to get that running when they have a battery full of juice, basically ready to go. So I think the economic incentive for the utility is to use those resources first. Use the wind and solar when it's available, and use the battery primarily. And again, P&M has that other cap, the 400-pound CO2 cap, that not, kind of throws the economics out the door and says, no, we need to meet this. Not that it throws the economics out, because they can buy from the market, and that doesn't count towards that CO2 number. But as we've seen we'll probably see it again one more time this summer. They have been buying extensively from the market over the last number of summers, because remember, they haven't put in new resources for quite a while, until the actual new resources that aren't San Juan or Palo Verde replacements aren't going in until 2026. So right now we're kind of in a limbo zone. We're right on the edge, as far as LOLE. We're nowhere near 0.1 right today, I don't believe. I think we're much higher than that until the 2026 resources come in. And so they definitely don't have a gold-plated system right now. They're buying a lot from the market. And I think you can see that in the rate case filings, how the sales and the purchases from the market drop off substantially in the test year, in the 2026 period, because they'll finally have the resources available in 2026, and then again in 2028, to where they can wean themselves from the market and the uncertainties of the market.
Okay, thank you. I appreciate that. Let me ask you just about the LOLE. We've had a lot of discussion about this today, and I just wanted to ask staff, the 0.1 LOLE. There's been a lot of testimony from P&M's witnesses about how that's sort of the national standard. Is that consistent with staff's understanding, both in New Mexico and then nationally, that 0.1 LOLE is the general standard?
Yeah, that's our understanding, is that it's ratcheting down. Plus, renewables add some uncertainty to the whole equation. So the old 0.2 that P&M used to live under is just not the safest bet anymore. Plus, I think the Western Resource Adequacy RAP is pushing more to that 0.1 standard, asking the utilities to meet criteria that's more in line with that before they enter the RAP program.
Okay. Another one of Chair O'Connell's questions that we asked to, I believe it was Mr. Wintermantle, was about what was a more reliable metric, the LOLE or planning reserve margin. Does staff have a perspective on that issue, or generally would you associate yourself with what Mr. Wintermantle said on that?
Yeah, I agree with Mr. Wintermantle on that you're back calculating the reserve margin. Really, you're trying to hit the 0.1 and then you're back calculating the reserve margin. I mean, if you looked at, I mean, from a capacity standpoint, P&M could run pretty much their whole average load with just the solar on the system right now. But that doesn't mean that the solar is available at 8 at night, you know, so that the whole capacity of the system and that whole, you know, if you look at that way, then it's really much different than it used to be. And so that's where they have a lot more total capacity. Now it's not capacity that's always available. So that's where the ELCC number comes into account, you know, what's available when you actually need it. But the total capacity on the system is much higher than it's probably ever been. It's just not always available when contemporaneously with the load. And so those numbers can change dramatically over time.
And then just a couple of follow-up questions just based on your testimony. So this is looking at, I guess my first question, and there won't be many, but page 7 of your direct testimony. You talk a little bit about the Sunbelt project providing a small excess and reserve margin for the system in 2028. And that excess is quickly evaporated in subsequent years. And then you cite current and potential economic development load growth. And I know that that's a hot topic, and I don't really disagree with any of that. But I guess my question is, you know, when you're assessing the prudence of that, are you looking at data or estimates of that load growth, or how does staff go about sort of assessing what that load growth is going to look like?
Well, I know personally I'm involved in that case number, the 24,257. So we've looked at some of the numbers that have come in from the various IOUs, including Pnm. And you know, if you get 100 or 200 megawatt data center that's running 24/7, that 100 megawatts of solar and 50 megawatts of battery is you know, it doesn't last very long. You know, it'll be absorbed very quickly. So if any of those projects come in, and there was multiples of those, if just one of those comes in, it'll chew up that Sunbelt project pretty much immediately. So it's not a hard, you know, it's more of a subjective statement than a true you know, any analysis, but from the numbers that we've seen on potential load growth and just customer requests, it seems like that 100 megawatts of solar and 50 of battery is a drop in the bucket of what's going to be needed in the future.
Okay, that makes sense. Another question, and you may not know the answer to this, but just up above, still on page 7, just up above that answer about economic development load growth, you explain that the Sunbelt project is going to create jobs in this hard-hit area of the state. You say that Pnm estimates the total construction effort to be about 300,000 man-hours of labor. Is there an estimate at all that staff has, maybe provided by Pnm or otherwise, about sort of the permanent job growth or the long-term job growth sort of beyond the construction of the project initially?
You know, we didn't ask that question. So yeah, I don't have a good number for that. I'm sure Pnm could supply that, but yeah,
And that's
certainly
fine.
It's certainly not in the scale of the old power plant, but
yeah,
but
no, and that makes sense. I mean, it stands to reason that there would be some job growth. I was just curious as if there was an estimate as to how much. And then I guess my last question, you know, you make this statement, this is at the sort of the top of page 5. And you make this statement here that I thought was a little bit striking. You say that the Sunbelt project is not the lowest cost resource option, is not absolutely needed to meet the 2028 resource demand, and the additional 20 megawatt BESS capacity was not by itself competitively bid. And you talk about balancing those issues against the following. And this is my last question to you, but essentially, one of the standards for hearing examiners to look at and for the commission to look at with a certification or with a stipulation is whether the stipulation violates any important regulatory principles. And so what I'm sort of interpreting from this is that, there may be some regulatory principles that are in question here, but we sort of need to balance those against, the benefits of the project. Is that sort of a fair summary of your testimony?
Yes, like you, I read that last statement in the third, or in the, in the independent evaluator's assessment. And basically, he chose the 3 projects, the PPA and the 2 ESAs, agreed with that and said the Sunbelt project, if you have other motivations, basically, then, go forth. This, you could debate if that 450 in the ETA is a cap, is it a minimum, is it somewhere in between? I was part of Energy and Minerals when our secretary was pushing the ETA, and we had meetings with the drafters of that legislation. I don't pretend to know what exactly was understood by the legislation when they signed it, but it seems to be in line with what was displaced at the time. And so if PNM and the parties want to push for getting that capacity back into that region, that school district, then staff can support that goal, if that was the understanding at the onset. And so we think that on balance, the other things can be, ameliorated, I guess, or pushed down as far as the priorities as to this. I'm like I said, PNM admits that that extra capacity is not needed today or in 2028, but once you hit 2029, it could be needed if a large additional load comes online. So we're looking at things that are 2-3 years out, 4 years out, and trying to make an assessment. And if something comes in tomorrow, it will look good if we allowed it to go through. So it's hard to, with the current load growth, it's hard to not allow a little bit of extra to go in, especially with all the discussions on economic development and stuff that's been going on.
Okay. Thank you very much for your testimony, Mr. Zigich. I appreciate it. Hearing examiner Ryan, anything to follow up on what I was asking? Okay. Let's see, Mr. Rossi, any questions on redirect, sir?
I do not. Thank you.
Okay. Thank you. Well, with that, Mr. Zigich, thank you very much. We appreciate your testimony today.
Thank you.
Okay. So I believe that concludes the testimony and the evidentiary portion of the hearing today. I think there's just a couple of items that we need to clean up procedurally before we conclude. So the first one, hearing examiner Ryan, let's talk a little bit about that second bench request. So staff, at least from what I saw, answered a lot of those questions that we had. Do we still want to issue that bench request to staff and to PNM and NMDOJ?
Yes, I do.
Okay. I'm wondering if the easiest way to do it wouldn't be, I mean, we can sort of instruct them to answer the questions here and then maybe to issue a filing, sort of writing down those questions. That way NMDOJ would have something at least in writing to process. Does that make sense?
Yes, I mean, we have to go back to what Commissioner O'Connell was interested about and look at the transcript. Yeah, I am happy to provide an order when there's time to do that.
Okay. So Mr. Rossi and Mr. Atencio, so you can expect a bench request on with respect to those questions. We will issue it in writing as a filing with instructions probably after the transcript is filed. Any questions about that?
Thank you for reducing it to writing. I think that will be very helpful.
No questions. And again, I also appreciate having a written order. I know our staff are getting to work on that already, so we should be able to have something for you shortly, and in line with the written order.
Yeah, I think hearings in Crown Camp is frozen. Oh, it was kicked off Zoom entirely. Oh, no, I think he's back. It's the Zoom ghost telling us it's time to go.
Okay. I'm back. I was kicked off Zoom. I don't know why. Where did we leave off?
Mr. Atencio is going to get us the answer to the second bench request shortly.
Okay.
And then we'll provide an order reducing what was said previously.
Okay. Good.
In the hearing.
Okay. That sounds good.
We don't need briefs. I mean, right? So I don't think we need him to tell us. I mean, the end, the question is, I'm not sure that I heard, based on the evidence submitted, what is the cost for the ratepayers? If you tell them, hey, you got to now buy all this new stuff, here's what this is going to cost. Well, that's what the bench request is about. I would further tell you that, what I heard Mr. Zigich talk about in terms of, how does this address curtailment questions? What is this sort of the longer term trajectory of Pnm? I mean, these are all things that it's very useful to supply in testimony. And I will say the testimony from staff where it was, here's what the stipulation is and here's what each section does. Well, again, I can assess that on my own. I think what would be more useful to know from staff's perspective is, why should ratepayers pay for this? Why should they? And I think there's lots of answers in there as to what but again, I don't want to be the one supplying them in the first instance. And part of the bench request from Mr. Monroy to find out how much you're going to pay per month is part of that. But then more broadly, what is it that we're trying to achieve as a regulatory community, as a state, and how does this fit into that broader trajectory? And why should you have to bear the cost of it? That's what we need to figure out. So that's what this case is all about. It's an unopposed stipulation. I think I can just say for confidence in the future, like when you provide stipulation testimony, it's not important to us that you tell us section such and such says that, this is an agreement that can't be amended. And if any section is amended, then the whole thing is gone. Like I can read that. What I would like for you to tell me is, why should the commission grant its imprimatur to this particular resolution of the issues? And why is that in the public interest? So I would welcome any further statements from anybody on that subject. And I frankly, if that requires you filing supplemental evidence, then do it. Because that's in fact the charge we're actually asked to satisfy. So you'll get bench requests from us, but that's the task before us. And I just really don't, I guess I will say for the future, please do not supply stipulation testimony that tells me what are the boilerplate sections of the stipulation. We don't need that. It's redundant, and we have the capacity within the hearing examiners division, and the commissioners certainly do as well, to understand fully that the stipulation is a manifestation of the intent of the individuals present. What we need to know is, why is this a good deal? So start there, and then from thereafter, everything flows downhill from that question. This is a good idea. My diatribe for the day.
One other procedural note, Mr. Atencio, at the beginning of the hearing, towards the beginning, I know it was in the morning, there was a request from hearing examiner Ryan about a statement that PNM would file, sort of a very condensed brief. Do you recall that discussion?
Yes, Mr. Hearing Examiner, a brief legal statement in regard to the ETA requirements.
Yes, and I just want to tag on to that. There's one other item that I'd like you to just address, and again, it doesn't need to be at length, but we've had this reference at towards the end of the hearing today about the statement from the independent evaluator about assuming that this, assuming that there is a requirement in the ETA about building, about putting these resources in CCSD. And my question to you, I know there's been a lot on that issue. My only question, I guess, is that an assumption that we need to resolve? Or is that not an issue that we have to make a determination on as part of the certification? Does that make sense?
Yes.
Okay. And obviously, if any other party wants to file a response after PNM has filed their statement, I mean, I don't think we're going to prohibit you from doing that. Okay. So those are the two items that I had. Hearing examiner Ryan, anything further that we need to address?
No, thank you.
Okay. Any procedural items or any questions from the parties about where we stand, where we're going, anything at all?
Mr. Hearing Examiner?
Yes. Go ahead, Mr. Atencio.
If it would be helpful, PNM's happy to prepare a draft certification of the stipulation, if that would be helpful for you.
No, thank you. And part of the reason I say no, thank you, Mr. Atencio, is, you know, we're looking very hard at how we write these documents. One of the things that we've discussed as an agency, and I'll just say this out loud because I think it's important that the entire regulatory community, you know, there's a premium placed upon describing events and describing the arguments of persons. For instance, you get an application and then we're told later on subsequently that there's a summary of this party is saying this and that party is saying that. And then you oftentimes will see an RD that says this party is saying that and that party saying this. And then that goes on to the final order. This is party saying that, that's part. And what I think is missing in a lot of that, and it's something that I've reflected on for the time I've been at this agency, is the question about, like, how do you write something concise to the point and that addresses legally only that which is necessary to be addressed? You know, the recommended decisions do not need to be full articulations of every aspect of the record. And oftentimes you find that they are. And there's lots of historical reason why that's the case. And we don't need to talk about it all now. But I think fundamentally we need to think more carefully how the writings actually come out, what they're doing, what is the purpose of them, how do they interact with the actual record itself, and how are they not a substitute for it, but simply a product of assessment of that factual record? So the point is, no would be the answer to the question. Do we need one? And then secondarily, I don't think that what I think these writings will look like in the future are sort of in any way modeled on what was the past. And then this actually gets more profoundly into the practice of the commission more generally. Like, we've been going on about this notice project for some time. And I will tell you, Mr. Atencio, that PNM continues to supply to us notices that, and that's not just PNM, it's the other investor-owned utilities as well. Sometimes we'll include incorrect telephone numbers. As call this person at this agency. Well, that person doesn't exist, or that number is false. I call the number on the proposed notice and it goes to a nothing. And so that sense of, we do something because we have a format in which we do it is something that I think needs examination at all times. So that's the long answer to your question.
Understood, and thank you for the explanation.
The short answer, Mr. Atencio, we do appreciate the offer, but we'll take it from here.
Thank you.
Let's see, anything further from any of the parties, any other items we need to address before we conclude? Okay, seeing none. Thank you all for your participation today. We appreciate it. Please stay tuned for those bench requests. But again, we appreciate your participation and professionalism today. And with that, we're off the record. Thank you.
Thank you.